Hello, my dear students. So, a very good evening to every single person. First of all, I know day after tomorrow is the exam. Still, people have doubts and we are tensed. We are not ready for the examination. We have not completed our preparation. So, don't worry. I will be here on the YouTube live for I think the next 3 to 4 hours. So you can ask me any query that you have. But while I am discussing a question, I request you to listen to the concept because we just have 1.5 day left for the big day. So small minor doubts, try to understand the question by yourself once again and clarify by yourself. So firstly, I hope your revision is going well and I wish you all the very best, and I'm looking forward for an easy paper so my students will all get 70s and 80s. So we are done with the introduction. Now firstly, I will help you clarify what I'm going to discuss in this live session. So of course, this video is for the purpose of important questions. So I am going to revise the important questions which are relevant for the June 2026 attempt. So firstly, I'm going to start off with the Companies Act 2013. So some of the case studies need detailed explanation. So for that case study based questions, I will give detailed explanation. So if the question is a direct question, I'm going to just read the question and tell you what will be the answer and I'll move on, because we don't have a lot of time to sit and listen to a full-fledged class once again. For that, already marathons are available. Okay. Now, after we are done with the Companies Act 2013, I'm going to move on with the other modules like IBC, corporate governance and the economic laws. Now comes clarity. So, many students have asked if there will be a new video for the bullet MCQs for the June attempt. My answer is no. The old video, which is applicable for December 2025, is also applicable for June 2026. You can refer to that video and that is more than enough for you. But there is one MCQ where I have specified under IBC 2016 that when the time extension is requested, what will be the total number of days within which the CIRP has to be completed. Previously, based on ICMAI suggested answer, it will be 180. But based on the suggested answer, now you have to choose 270 days. That is the only one MCQ which is different from the December 2025 video. So I hope I've clarified. Now, moving on to case study based MCQs. So case study based MCQ till now for this attempt I have not provided a PDF. So I'm aware about the fact. So tomorrow I am going to come up with another live video to discuss case study MCQs. That will be around 1 hour. That's all. So if you invest around 1 hour of your time for case study MCQs, maximum I'm telling you, that will be enough for you. So tomorrow I will share the PDF and tomorrow we will have a live class for case study MCQs. So I have clarified regarding the case study MCQs also. Now comes the presentation guidelines. So already full-length video on what are the ICMAI guidelines and how to present the law answers and what to avoid. So all these matters I've discussed in a video which I have prepared I think 2 attempts ago, which is right now also you can use that video to refer, where you will get all these videos. First, go to BCCA YouTube channel. In the courses, you can find my law marathon live course. So here you have the bullet MCQ video which you can refer, and you also have this, see this, why your answers are not scoring. So this will be the law presentation video that you can refer. I request you to once see the video so that you will understand how to present and what mistakes to avoid during the presentation. And the marathons are also there. Part 2 marathon is there. First part marathon is also available. So you can refer to this course for any sources. Even this live video is also there in this course. Okay. So I hope I have clarified most of the doubts. Now I'll just see the comment section once. Good evening, everyone. Compromise unit, yes, compromise unit is important. Why? Because there is an amendment related to fast track mode of merger, section 233. So it's better to just at least revise the important questions and MCQs of compromises unit. Directors, from director the expected mark, for sure 21 marks will be asked. In my opinion, 3 7-mark questions can come from board of directors and board meetings. So we'll see based on the paper. You're skipping FEMA, prevention of oppression. It's up to you, my dear. If you are okay, if you are perfect with the other units, you can skip. You want to write corporate governance questions in your own terminology rather than using the book language. So I recommend you to at least whatever the words that I have highlighted in red in my concept book or in my question and answer book or in the important question PDF, that red highlighted words should be there. Why? Because ICMAI is very particular about the terminology. If you're not writing terminology, it's not even considering giving at least 1 to 2 marks also. Some of the papers were brutally corrected like that. So make sure at least some red highlighted word in the initial 1 to 2 points you have used. Ma'am, for other subjects also can we get live like this? I have no idea, my dear. So anti-money laundering, yes, you have to revise. So now getting into the sources. So all the sources, important questions PDF for Companies Act and important questions PDF for other modules starting from IBC till PMLA, all these 2 PDFs updated with MQP June 2025. Currently, just recently 10 to 20 minutes ago, I have shared in the Telegram channel. Download that and refer to that PDF. And June 2026 bullet MCQ PDF also, it is there in the pinned message of my Telegram channel. Telegram channel link is in the description box below. Okay, so now one more one more concept where students have discussed like million times in my Telegram channel. They have mixed opinions of what the limit should be. This is for section 182, political contribution. So based on the ICMAI practice question paper, practice test paper, as well as based on the study material, they have specified that there is no limit. But I am again clarifying you, and I have clarified in the previous video also, this is not what you have to prepare for the June 2026 attempt. Why? Because initially the limit which is there 7.5%, that was omitted by the Finance Act 2017, but later on based on a Supreme Court judgment the omission was struck down. So please make sure ICMAI can surprise you. If you write down no limit and in the suggested answer it gives 7.5% based on Supreme Court judgment, we cannot argue. Why? Because this is the fact. The fact is that Supreme Court has struck down the word that there is no limit. So of course limit is there, 7.5% of the preceding 3 profit of the preceding 3 financial years. This is another clarification I am providing for you. Past paper, practice question paper have not even considered some of the 2018 amendments. So relying based on just practice test paper can't give us assurance of what should be written and what should not be written. So that's one thing that I want to clarify. So if you want to skip banking, yes, you can absolutely skip. Ma'am, MSME chapter MCQ in the question 2 MCQ PDFs. So MCQ MSMEs you have to learn based on the new limits. New limits are applicable for the December 2025 as well as the June 2025. Based on that you make your correction. Small company limit, again I am clarifying you. Small company limit, paid up share capital, maximum 4 crores and turnover maximum 40 crores. So these two are the most asked clarifications in my Telegram channel. So this is what I will answer for all the queries regarding that. Now, then what to write if we get political contribution? Already in the important questions PDF, there is a question in Unit 6. Unit 6, there is a question on 182. If the question was asked like that, how to answer, what to be written, everything is there in the important questions PDF. And important questions PDF, I have also updated regarding the small company also. In the old PDF, I have not updated because that was applicable for December 2026. So here also I have updated. So that's why please refer to the new PDF. Investment company layers, 2 layers, no doubt about that. The provision is 2 layers. Now I will start with the session. So we are going to start with the module 1, which is the Companies Act 2013. So I'm at the beginning itself, I'm giving you a clarity. Ma'am, we have already completed our revision. We have some of the other personal targets that we have to complete. So then I recommend you not to watch the video because I'm not going to interrupt with your preparation. Clear with this? You continue with your targets if you're clear. But if you're tensed and you have so many doubts and you want a support from my side to start revision very quickly, to know how to learn and what to be the presentation style, all these will help you with my video. So if you're already clear with your targets, do not watch this video because you will be confused. Follow the preparation strategy that you've been following. Are we clear? And don't forget to watch the case study MCQs that I will be releasing tomorrow. So that's all regarding this. Now, firstly, so for the students who are active in the comments section, just heads up, I'm starting the revision. Please sit down wherever you are doing your preparation, get your books, get the PDF you can download, in your phone you can watch, or in your iPad you can watch PDF, your books, take a pen or else a pencil and start highlighting what is the important word, whatever I am explaining. This should not be just like a random web series you are watching. This should be 2 ways. You have to learn with me. I hope I'm clear with this because we don't have a lot of time to waste on just seeing the video again. I will start the preparation. You have to do the preparation with me. So I'm telling you once again, after few minutes, after around 40 minutes, once again I will see the chat box. Then you can ask any doubts. MCQs video, case study MCQs video, the beginning itself I clarified. But the students who are attending now, just go back at least 2 to 3 minutes, then you can see the update regarding MCQ videos. So let's start. So firstly, we'll start with Unit 1. Okay, so Unit 1 is regarding company formation and conversion. So firstly, the question is regarding small company. So what's the question saying? MNP Private Limited is a company registered under the Companies Act 2013. Now, paid up share capital is 2 crores. What is the paid up share capital? 2 crores. And turnover is 60 crores. Now, firstly, we'll understand what are the limits. Limits applicable for June 2026. Small company means a company which is other than public company. So, in question it is clearly mentioned it's a private limited company. So, first condition is satisfied. Now, moving on to the threshold conditions. Firstly, the paid up share capital cannot exceed, what is the maximum paid up share capital? 4 crores. And that means both the conditions should be satisfied. And turnover as per the latest profit and loss account shall not exceed 40 crores. Are we clear with this? So maximum turnover is 40 crores. Maximum paid up share capital is 4 crores. Based on this threshold limits, if you check the maximum paid up share capital 4 crores condition is satisfied. It is less than 4 crores. First condition is satisfied. Now if you check the second condition, maximum should be 40. But how much is the value over here? 60 crores. but both the conditions should be satisfied. So that is why MNP Private Limited cannot avail the status of small company. Let's continue with the question. Examine the following in accordance with the provisions of the Companies Act. First question. Whether MNP Private Limited can avail the status of small company? Answer will be no. Why? Because both the conditions should be satisfied. Only one condition is satisfied. So that is why it cannot avail the status of small company. Now, what will be your answer if the turnover of the company is 30 crores? 2 crores paid up share capital limit is satisfied, and here turnover is also less than 40 crores. So if both the conditions is satisfied, yes, it can avail the status of small company. Now, how to present the answer? This is a case study MCQ. This is a case study question. First, how you have to start? First, you have to start with the provision. What will be the provision? You have to write down the definition as per the Companies Act 2013. Write down the definition, and first you will write down the provision, then you start numbering. First question. What's the first question regarding the limit of 2 crores and 60 crores? So you will write down about the present case. Present case, paid up share capital is 2 crores and turnover is 60 crores. Now comes the explanation. Since only one criteria of share capital not exceeding 4 crores is met, but the second criteria of turnover not exceeding 40 crores is not met, the provisions require both the criteria to be met in order to avail the status of small company. MNP Limited cannot avail the status of small company. Simple. It cannot avail the status of small company. Now comes the second. If the turnover of the company is 30 crores, then both the criteria will be fulfilled and MNP Limited can avail the status of small company. Simple question. Now we'll move on to the second question. I hope I am clear with this. This is the last minute, my dear. You don't need to remember section numbers. It's very high time. You can't waste your time or you can't waste your efforts in remembering the section numbers. Remember whatever you're sure about and do not write if you're not sure. That's all. So next question. Gautam of Uttar Pradesh incorporated a one-person company. So one-person company is incorporated by Mr. Gautam. In compliance to law, he appointed his brother Rohit as nominee. So if you are the sole member of one-person company, for sure you should have a nominee. What is the role of nominee? In case of your death, the member's death or incapacity, who will become the sole member of one-person company? Nominee will become the sole member. So that is why nominee is required to be appointed. And if you are appointing the nominee, we need the consent of the nominee. Are we clear with this? Now, here both are residents and Indian citizens. They have to be Indian citizens whether resident or not. So, but here both are residents and both are Indian citizens. Well and good. Now, on 12th of February 2024, Rohit left India permanently to settle in Dubai. He has gone out of India. Okay. And he has withdrawn his nomination. Can a nominee withdraw his role of being a nominee? Yes. But what has to be done? He has to inform to two persons. He has to inform to the one-person company as well as he has to inform to the sole member. Are we clear with this? Now, you are required to answer the following in the light of the provisions of Companies Act. Now, what action shall be taken by Gautam when he gets notice of withdrawal of nomination and within what limit? So, as a nominee, your responsibility is to give a notice to one-person company as well as the sole member. That is done. Clear with this. Now comes the responsibility of Mr. Gautam, who is the sole member. We need to have nominee, but the sole member is not having the nominee. What he has to do? He has to inform to the ROC that this particular person has withdrawn his nomination and now he has to appoint another nominee. That another nominee's consent also you have to take and file it with the registrar. Simple procedure. So what is the procedure? First, Sole member of one person company shall nominate a person after obtaining prior written consent of such person. First you have to nominate, you have to get the consent. Now, who shall, in the event of death or incapacity of into contract, become the member of one person company. So in case of death or incapacity of the sole member, who will become the sole member? Nominee will become the sole member. That is the first sentence which is saying. Now, person nominated by the member of one person company may withdraw his consent. Whenever he don't want to act as a nominee, what he can do? He can withdraw his consent. But what he has to do? By giving a notice in writing to sole member and the one person company. This is the first obligation. Now, after he is done with his obligation, he will leave. Now, what should be done by the sole member? He has to nominate another person. He has to nominate another person. Now comes time limit for nomination. So, he has to nominate within 15 days of the receipt of such notice. Are we clear with this? And then shall send an intimation of such nominating in writing to whom? To the one person company. Sole person has to intimate to, sole member has to intimate to one person company. One person company will intimate to the registrar. This will be the procedure. Clear with this? Now, sole member has to appoint within how many days? Within 15 days. Are we clear with this? And of course, that new nominee's written consent shall also be sent to one person company. And the declaration will be filed in which form? This is the important form. Form INC 4. Are we clear with this? Now, the other person will give a declaration regarding the nomination in Form INC 4. Same Form INC 4 will be filed with whom? With the registrar. Are we clear with this? So, one person company within 30 days of the receipt of the notice of withdrawal of consent, file such notice, the intimation of the name of the other person nominated by the sole member with the registrar in the Form INC 4. This is the procedure. So, sole member has to appoint within 15 days. Now, one person company has to inform with the registrar within 30 days. Both the cases, what is the form which is used? INC 4. Are we clear with this? That's all. So, what will be the procedural requirements? Nominate another person and file the details in the form INC 4. Now, moving on to the second question. Gautam wants to appoint his minor son. Whom you are appointing as nominee? A minor. Can you appoint a nominee as a minor? Absolutely not. So, examine with relevance and correctness in the same. So, here as per the rule 3, no minor shall become a member or nominee of one person company or can hold beneficial interest. So, minor can't be a member. Minor can't be a nominee. Minor can't have beneficial interest. So, what will be the conclusion? Gautam's minor son Abhijit cannot be appointed as nominee. And now, nomination has to be done within 15 days. If the person fails to do so, what is the penalty? That is only the last question. In case Gautam fails to appoint a new nominee, what shall be the legal consequences? What will be the legal consequences? Penalty. First, fixed penalty which may extend to 5,000 and continuing penalty 500 for every day after the first offence during which the contravention continues. You have to appoint within 15 days. From 16th day, every day 500 will be your fine. That's all. So, we are done with the second question also. Okay, once again I am clearing this doubt once and for all. You don't have time to go to another source. Just one day is left. For one day is also not enough to complete all the question and answers and the MCQs. We have to do it quickly. We will not be able to do it effectively. So if you ask me, are these enough? I will tell you for the 1.5 period, 1.5 day that you have, these are enough. Revise these. Revise the bullet MCQs. Revise the case study based MCQs. Because we don't have a lot of time to go open another source, do both, not possible. Do this one. This already has MQP June 2026 also. This is color coded. It will be very easy for you to revise. Whatever you remember, write down. Are we clear with this? So that's what I have. This live will be available later on also. So if you don't want to prepare right now, you want to prepare tomorrow or at the night time, this will be available in the live till the examination. Okay. So now the next important question, it's a direct question, so I'm not going to discuss point wise. I'm giving you a clarity regarding this. What is the question? What are the documents to be delivered to the ROC, that is MCA, by foreign companies for registration? So if a company is incorporated outside India, now it is starting a place of business in India, it has to follow the Companies Act 2013 before it starts its establishment in India. For that, it has to file few documents to the ROC. That to which ROC? Since the company is incorporated outside India, it should file all these documents to the ROC of New Delhi. Not any state, ROC of New Delhi. Now this question is regarding what documents as a foreign company I have to, like as a foreign company has to file to the ROC. Are we clear with this? So we have given a list of documents and all these documents should be filed within 30 days of the establishment of place of business in India. What are the documents? I'll just give you an overview. I'll highlight. First will be, so that particular company in that country also will have memorandum of association, articles of association. Those may be called as charters, statutes, memorandum. That has to be filed. Clear with this? So charters, statutes and memorandum. Clear with this? If it is not available in English language, then you have to give it in translation version. Are we clear with this? And if it is incorporated in Germany, what is the principal office address? That details you have to give. And list of directors and the secretaries. Clear with this? And then the name of person. You need a person in India who is authorized to receive all the documents, notices regarding that foreign company. That person's name in India, the authorized representative name should also be sent. Clear with this? So, name of one or more persons resident in India authorized to accept on behalf of company service process any notices and other documents. And then here in India, what is the full address of your company? And the next one, declaration that no directors, no authorized representative is convicted or debarred from formation of companies. They should be clean. Clear with this? They should not be convicted. They should not be debarred from formation of company. That is the sixth point. And the last point will be any other information as may be prescribed, and all these documents have to be filed within 30 days. And if there are any changes in the address, changes in the documents, within 30 days of the change, you have to inform to the ROC. Now, which ROC you will inform? The ROC which is having a jurisdiction over New Delhi. Clear with this? So this is the concept regarding foreign companies. Now comes another direct question which was asked many times in the MQP but never asked in the final exam, but it is asked in the MQP June 2026 also. That is why I have included this in the important questions. What is this question regarding? This question is regarding conversion of LLP into private limited company. What is the procedure that you have to follow? So let's read the question first. X & Co is an LLP firm wants to convert their firm into a corporate entity. As per the provisions of contained in the section 366 of the Companies Act. Which section you have to follow for conversion of LLP into company? Section 366 of the Companies Act 2013. Now, and also they have to follow the authorized rules 2014. Now, they have conducted a meeting for conversion of and to decide the name of the company summoned for the purpose of registering the LLP. They have held the meeting because they have to discuss important details. Okay, well and good. Now, in the meeting, 1/4 partners want for conversion into private company and 3/4 partners want the new corporate entity with the word public limited company. Okay. Some of them want private company, some of them want public company. Now, there are 6 partners in the firm. Recommend an appropriate decision and steps to be taken. First, to give appropriate decision, requirement will check. If the firm has at least 7 partners, it can convert into public limited company. Why, ma'am? Very basic. Because for public company, how many are the minimum number of members to incorporate? 7 members. So that is why if you have 7 partners, then convert into public limited company. If not, what is the best option and what you have to recommend in this case? Convert into private company. Because how many partners are there? There are only 6 partners. Are we clear with this? Now, we'll check the process. Again, process is a bit lengthy, so you can revise it yourself. I'm just going with overview because this is not a case study type question. It's pure theory. Clear with this? Now, if you want to convert LLP into a company, you have 2 options. First is to, all in all, keep the LLP aside, dissolve the LLP and incorporate a new company. Clear with this? From the scratch, MOA, AOA, director, Spice Plus form, everything you start. If you don't want that, you can follow section 366 and you have to file URC1 form for conversion of LLP into a company. Clear with this? So you have 2 ways to initiate this. First is to incorporate a new corporate entity. Second, conversion of existing, that is LLP or partnership firm, into a company. Now here we are referring to LLP. Clear with this? Now, firstly, an LLP must have at least 7 partners for public company, 2 partners for private company. Now, in our case, there are only 6 partners. What is recommended? Private company is recommended. Clear with this? Now, you need the approval of all the partners. Now comes the important requirements. First, approval of all the partners. You have to give an advertisement that this LLP is being converted into a company, and you should take a no objection from ROC of the LLP, which is registered with that ROC. That ROC should also give no objection for conversion. ROC will check all the requirements. Clear with this? And then this is regarding small LLP concept. Small LLP means an LLP whose annual turnover is less than or equal to 40 crores and capital contribution less than or equal to 25 lakhs. So, sorry, 40 lakhs and 25 lakhs. But if you have 40 lakhs of turnover and 25 lakhs of capital contribution, you can easily convert into company. This procedure you can follow. So, however, if an LLP crosses an annual turnover of 40 lakhs, capital contribution of more than 25 lakhs, the compliance requirement of LLP and private limited company become almost similar, making the private limited company a better option. Are we clear with this? Anyways, you are LLP. Most of the requirements legally are similar to a private company. So, it's better for the transition into a private limited company. Are we clear with this? Nowhere you didn't need to write down about small LLP. Clear with this? But the definition is regarding small LLP. That's all. So, further, the company with less than 7 members shall register as private company. Even if majority is for the new entity, even if majority says we want public limited company, but there are only 6 partners, so what is the better option? Private limited company. Are we clear with this? Now, let's move on to the following steps that you have to do. First, requirements we have seen. At least 7 partners should be there. Approval of all the partners is required. And you need a no objection certificate. I'm really sorry. We need a no objection certificate from ROC. And the next one is you need to advertise in both local newspaper as well as national newspaper. These are conditions. Now, we'll see the process. Firstly, to decide the name of the new company and to decide the procedures of LLP, you have to do the basic thing. What is it? Hold the partners meeting. So, what is the first requirement? Hold the meeting of the partners to decide the name of the company. Are we clear with this? Now, again, all the necessary steps regarding documents, deeds, agreements, all that will also be discussed in the meeting. So, to authorize partners to take all steps necessary and to execute all papers, deeds, documents pursuant to register of the LLP as company. All the requirements, discussions should happen in the meeting. That is why hold the meeting. That's all. So, major advantages, as one of the advantage over here is, if you are converting into a private limited company, what you can do is you can use the same name of the LLP. So, major advantage are that the business can be run under the same name. as that of the LLP, except that in addition to the name of the LLP, the words limited or private limited has to be added. And we all know regarding the concept of name reservation using the Spice Plus form. Here also you have to reserve the name, and the name will be reserved for 60 days. So the accepted name by the authority will be valid for how many days? 60 days. That's all. And as partners, since we are now acting as directors in the company, and if you are acting as director, for sure you need to have digital signature certificate as well as director identification number. See, these both should also be applied for. If you don't have DIN during the incorporation procedure only, based on INC 32 form, you can apply for director identification number. This is the point that is telling. So after obtaining the name approval, apply for digital signature certificate and director identification number for the member of the LLP who will be the directors of private limited company. So if you don't have a DIN, the applicant needs to provide address proof, identity proof and photographs along with the application. Therefore, they can directly apply for DIN during incorporation. So, to write down a summary, first meeting, second name, third DSC and DIN. Are we clear with this? And the fourth is URC. URC1 has to be filed. So overall, these are the requirements for starting and converting LLP and starting a company. Clear with this? So further, form URC needs to be filed by the applicant. Furnish the following list of documents. So basic details of members, directors, partnership agreement, all these details must be mentioned. So what are the details? Quickly we will see. First will be list of members. Members' name, address, shareholding. Next, list of directors. Directors' name, address, DIN and passport details. And the first director should be giving a declaration that we are not banned, that is we are not disqualified to be acting as director. So this is again basic requirement. And file all mandated requirements with the ROC. So simple: MOA, AOA, Spice Plus forms, PAN, GST, TAN, TDS, TCS, all these documents have to be filed with the ROC. Are we clear with this? And also you need to give the previous agreement of LLP. LLP agreement will be there, right? What is the profit sharing ratio? How much capital we have contributed? Based on this capital contribution, after we are converted into company, how many shares we have allocated to each partner? All these details regarding nominee and share capital, number of shares taken. This is regarding the last few points. And then again, no objection certificate from all the creditors. Creditors who have lent money to LLP should be aware that now LLP is becoming a company. Yes or no? So they should also be giving no objection certificate. And the last one will be duly certified account statements of the LLP by the auditor, which should not be less than 6 days from the date of application, and the copy of newspaper. Are we clear with this? So all these details regarding the accounts statement, at least 6 days before the application, that account statement you have to give it to the ROC. Are we clear? So that the financial position of LLP will also be clear. Now moving on to the last point. You should also draft the memorandum of association and articles of association of the new company and file it with URC1 to the ROC. So overall, what are the requirements? To summarize, what are the requirements? Process will be meeting, name you have to decide, and you have to apply for DSC and DIN, and you have to file URC1, and the last one you should also draft MOA and AOA. Are we clear with this? Ma'am, will this question can come? Why? Because it's there in the MQP June 2026. Last time MQP December 2025, one question exactly from company formation, it was asked, United Services Limited something. I have given in my important question, the same exact question was asked in the December 2025 main attempt. So sometimes miracles, surprises can happen. This may not come also. That's why I have given you an overview. At least remember overview and write down your own terminology. Clear with this? So how you will start? Two methods: incorporate a company convert. If you want to convert, you need to have 7 partners or 2 partners, approval of all the partners, advertisement, no objection certificate from the registrar. And what is the process here? Process will be meeting, name, DSC, DIN and URC1 and MOA and AOA. If you don't want to write this down, just simply write down, because there are less than 7 members of a private company. Majority, even if majority agrees for public company, they have to convert into a private company. So if you don't remember this 40 lakhs, 25 lakhs limit, do not worry, don't need to write down. That's all. Now moving on to the last but one question. This was asked in MQP June 2025. It's a very simple question. So listen, Ramesh, Rohit, Madan all graduated in pharmacy, decided to form a startup business of manufacturing rare medicine for cancer. Okay, they want to manufacture a rare medicine for cancer. Rohit plans big and wants to go for public, for finance in course of time. In course of time, he wants to go for public. Okay. Madan has requested his uncle, an NRI based at US, to invest in the company. So his uncle is in US and he's requesting his uncle to make investment in a company incorporated in India. Okay. Ramesh feels that they should go for Section 8 company as the target is not to make money. They don't want to make money. Okay. Now, Madan's uncle wants to know the advantages and disadvantages of public and private company in India. You are advised to critically assess the following. So, firstly, what question they have asked? In order to fulfill Rohit's plan, what kind of entity should be preferred and why? What was Rohit's plan? He's planning big and he wants to go for public for finance. So, even if he goes for public for finance, initially, compliances, requirements, number of members, if you check all these, what is better? Private limited company. Later on, you can expand into a public limited company. That will be the recommendation that we will provide. Next, can Madan's uncle invest in a company as an NRI, non-resident Indian? Can he invest? Yes. But what he has to follow? He has to follow the FDI protocol. Foreign direct investment restrictions he has to check, and then he can make investment. Next question. Ramesh's idea for Section 8 company, is it okay? First, if their motive is to make profit, and if their motive is to distribute dividend, then in that case they can't start Section 8 company. Are we clear with this? So that is one thing. And prepare a small note on Madan's uncle. What note you will prepare regarding advantages of private company, limited liability, ease of management and flexibility in ownership, because there are only minimum 2 members are required. Clear with this. Now, disadvantages of private company will be, you cannot invite fund from public and you cannot increase the number of members to over 200, and restrictions on transfer of share. This is the note that you have to give it to Madan's uncle regarding private company advantages and private company disadvantages. So, no, Section 8 company is not suitable because Section 8 company is for non-profit organization, meaning for promoting commerce, art, charity, education, and they cannot distribute or declare dividends. So, since the business is about manufacturing rare medicines, it requires significant investment and an option to raise capital through private or public funding. So, in that case, you can't go for Section 8 company. And then here, what will be the recommendation? Start a private limited company, later on convert into a public limited company by planning an initial public offer. That is what all the companies do right now. Now, the last question is again a direct question regarding the Unit 1, which is you have to write down about the doctrine of indoor management and doctrine of constructive notice. So, I am not going to go a little fast because here we need a proper explanation. What is doctrine of indoor management and what is doctrine of constructive notice? First, doctrine of indoor management. As an outsider, if I am entering into an agreement or a contract for purchase of goods or for loan, legal services, consultancy services, anything, as an outsider, I am entering into a contract or agreement with the company. I should be aware of only 2 documents. What 2 documents? Memorandum of Association and Articles of Association. That's all. I am not required to know what is happening inside the company. What are the internal procedures? Did they follow the conditions or not? I'm not concerned about this. What I will assume, they might have followed the conditions. They might have followed the internal procedures. So that is what I will assume. So indoor management doctrine is a protection to outsiders. Outsiders need not be aware about what's happening inside the company, whether they followed the condition, whether they passed resolution, whether all the directors agreed or not. We don't care, because we assume you followed it. What we should be aware about? Memorandum and articles. So that is what is the doctrine of constructive notice also. Doctrine of constructive notice says that outsiders should be aware of memorandum of association and articles of association before they enter into a contract. If that company is not eligible to enter into consultancy services and you are rendering consultancy services, what will happen? You are entering into a contract which is invalid. You are doing your own wrong. Are we clear with this? So law will not protect you. You should be aware of memorandum of association and articles of association even if you don't read it. That is why before you enter into a contract with the company, make sure you read memorandum and articles. If some power, if some loan, investment, service, good is not permitted under MOA and AOA, you render such services and company is not paying you back, you can't claim liability. Why? Because you should not enter. It is not permitted as per the MOA or AOA. That is the difference between indoor management and constructive notice. That's all. So here, the doctrine of indoor management protects outsiders dealing with the company in good faith by allowing them to assume company's internal procedures have been properly followed. We'll assume that they have followed. But once a company's MOA and AOA are publicly registered, outsiders are not required to check whether internal approvals, resolutions, procedures have been duly completed. Internal procedures we are not required to check. Clear with this? So it's also called as the Turquoise rule. Why? Because it is based on the case law Royal British Bank versus the Turquoise. So where it was held that third parties dealing with the company are not responsible for verifying internal corporate compliances unless there are some suspicious circumstances. That's all. Now, doctrine of constructive notice, which is opposite to indoor management. The doctrine of constructive notice states that once a company's MOA or AOA are registered with ROC, they will become public documents. So, this means that anyone dealing with the company is presumed to have knowledge of their contents, and even if they have not read them. So, outsiders cannot claim ignorance of these documents and must ensure that transactions comply with the company's stated powers. That's all. So till now, is everyone clear with the unit 1 questions? So we'll move on to the unit 2. Unit 1 has a lot of clarifications. That's why we are going slow. From unit 2, it will be very easy for us. Okay. So where can you get this PDF? You can get this PDF in the Telegram channel. Link is in the description box below. In the Telegram channel, you can check the pinned message. Okay, now quickly we'll move on to the dividends. So question number 7. XYZ Limited, having inadequate profits, proposes to declare 10% equity dividend out of its current profits and free reserves. So firstly, if the company is having adequate profits, it can declare dividends without following any conditions. But if it has losses or no profits or inadequate profits, it has to follow 4 conditions. First, we'll see the conditions first. What are the first 4 conditions? Condition number 1, about rate. How much rate of dividend you can declare in case of inadequate profits? So, rate cannot exceed the average rate of dividend declared during the immediately preceding 3 financial years. It's a long sentence, I know, but once again we'll read. Rate of dividend declared shall not exceed the average rates of which dividends are declared by it in the 3 immediately preceding years. Ma'am, please explain, directors. Yes, interested director also, I'll explain once again. Why? Because that question is there in the important questions. So that is the first condition. Now, second condition. Since you don't have profits, or since you have inadequate profits, from where will you declare dividends? What is the source available for you? The source available for you is free reserves. So how much I can withdraw from my free reserves? Maximum 10% of paid up share capital and free reserves. Are we clear with this? So, the total amount to be withdrawn from such accumulated profits shall not exceed 10% of paid up share capital and free reserves. That is the second condition. Third condition, you have withdrawn from free reserves. Yes or no? First, just a minute. I think I got a call. Okay. Yeah. So condition number 2 is regarding how much amount you can withdraw from free reserves. How much maximum? 10% of paid up share capital plus free reserves. Now, moving on to condition 3. Whatever you have withdrawn, the first thing that you have to do is you have to utilize for setting off the current year losses. How much ever loss you got, that loss you have to set off with the amount of free reserves with your withdrawn. Clear with this? Now, amount which is left out after you set off the losses, that amount you can utilize for declaring dividend. The last condition is, after you have withdrawn from the reserves, make sure the reserve balance of reserve is, it should not be less, it should be at least, it should not fall below 15% of paid up share capital. 4 conditions. First condition, rate. Clear with this? So what should be the rate? Rate can be less than or equal to D1 plus D2 plus D3 divided by 3. That is average rates of dividend declared during the immediately preceding 3 financial years. Are we clear with this? Now, how much maximum you can withdraw from free reserves? Less than or equal to 10% of paid up share capital plus free reserves. First, you have to set off the losses. And the next one, what should be the balance left out in the free reserves? It should be more than or equal to 15% of paid up share capital. So it cannot fall below 15% of paid up share capital. These 4 conditions should be satisfied. Clear with this? Now, based on these 4 conditions, let's see what are the financials which are given. So they have given regarding preference dividend. So you have to pay preference dividend around 9% and also equity dividend. How much they are proposing? 10% they are proposing. Clear with this? So 10% equity dividend has to be paid and 9% preference dividend has to be paid. Now, general reserve 21 lakhs, you will use it for the purpose of declaration of dividend. Yes. Now, capital reserves you will not be using because capital reserves is not a free reserve, and securities premium also will not be used. Next, what's the surplus in the profit and loss statement? This is also like a free reserve. Are we clear with this? So that should also be utilized for the purpose of declaration of dividend. So the 63,000 also you will use for declaration of dividend. And current year profit which is there, inadequate profit is there. So that means profits are there, but they are not sufficient for the declaration of dividend. So these both amounts also you will use for the declaration of dividend. So, how will you start? They have also given the average rate of dividend which is for the last 3 years, which is 15%. All the content is available. So, firstly, you will write down the provisions. 4 conditions. Well and good. Now, we'll write down the case study. First of all, how much preference dividend has to be paid? Clear with this? So, if we calculate 9% on 17,500 shares into 100 rupees each, so we get a dividend of 1,57,500. So, this is preference dividend. Now, equity dividend is 10%. So, 10% on 7 lakhs into 10 rupees, which is nothing but 7 lakhs equity dividend. So, overall, how much dividend we have to pay? 8,57,500. Are we clear with this? First, we'll start with the first condition. What's the first condition? Average rate. What's the average rate? 15%. So, our rate of dividend should be either 15% or less than 15%. So, what is the rate which the company has recommended? 10%. So first condition is satisfied. So that is what you will write down over here. Now let's see the profit availability. So first, net profits is 3,57,000. Credit balance in P&L, which is surplus, is 63,000. So total how much profit is available for us to pay dividend? 4,20,000. So if you reduce 4,20,000 from profits, from the dividend, additionally how much amount you want from free reserves? 4,37,500. Clear with this? This is the dividend amount. This is the dividend that you have to pay. This is the profit you have, but it is not sufficient to cover the whole 8,57,000. So that is why how much you have to withdraw from free reserves? 4,37,500. This is the case. Now we'll link the case with the conditions. So did we satisfy the first condition? Absolutely yes. Average is 15%. We proposed 10%, which is within the limit. So therefore the condition 1 is satisfied. Now what is the condition 2? How much you have to withdraw? Only 10% of free reserves. How much is the free reserves? The free reserves is 21 lakhs. Clear with this? Now how much should be calculated on 10%? Paid up share capital plus free reserves. What's the paid up share capital? Total preference share capital plus equity share capital, which is equal to 87,50,000. So 87,50,000 plus 21 lakhs, which is equal to 1,08,50,000 into 10%. So how much you can withdraw? 10,85,000. Clear with this? Now if you can withdraw 10,85,000, but you are required to withdraw how much? Only 4,37,500. So it is within the limit. So condition 2 is also satisfied. Now condition 3, since already we have profit, we don't have losses, so we don't need to set off. So condition 3 is also satisfied. Moving on to the last condition, balance left out in free reserves. If you withdraw 4,37,500 from reserves, how much is the balance left out? 21 lakhs minus 4,37,500, which is 16,62,500. So let's see the balance. 15% on paid up share capital. 15% on paid up share capital is 13 lakhs. But how much is our balance? 16 lakhs. So that is why it should be 13, but it is 16. So we have satisfied the fourth condition also. So all in all, what they have asked at the end, applying the provisions, calculate the minimum amount that is required to be withdrawn from free reserves. So what is the minimum amount that you have to withdraw? 4,37,500. So I hope I am clear with this. So yes. Now, ma'am, what happens if we declare dividend and the additional conditions do not satisfy in case of inadequate profit? Then relevant penalties will be applicable. You have to satisfy the 4 conditions, otherwise it will not be valid. You can't declare a dividend if you don't follow the conditions. That's all. Now, the next question, which is the last question of dividend, which is regarding section 127. What is section 127? Punishment for failure to distribute the dividend. As soon as you declare the dividend today, you have to distribute within the next 30 days. If you fail to do so, you will face penalty as a company and imprisonment as directors. So let's see. Here, Star Computers Limited declared and paid dividend in time to all its equity shareholders for the financial year. So all its equity shareholders have received the dividend in time. But except 2 cases. We'll see the first case. Mrs. Sheila Butt, holding 250 shares, has mandated the company to directly deposit the dividend into her bank account. So she wants the dividend to be deposited in her bank account directly. Okay, well and good. Company accordingly remitted the dividend, but the bank returned the payment on the ground that there was a difference in surname of the payee in the bank records. So some compliances regarding the name was not satisfied. That is why bank returned the payment to the company. Okay. The company, however, did not inform Mrs. Sheila Butt about the discrepancy. This is exceptions for punishment. So section 127 is saying that within 30 days, if you don't distribute the dividend, you will face punishment. But you will not face punishment if case number 1. The shareholder has given directions to the company. Company followed the directions but failed to pay the dividend. And company has informed about the failure to comply with the directions to the shareholder. Then no penalty. Here what happened? The company followed. Company failed. Did company inform to the shareholder? Company did not inform. So that is why the particular company will face the punishment. That's all. Next, dividend amount of 50,000 was not paid to the successor of late Mr. Mohan. They have not received this, the successor, that is the legal heir has not received the payment in view of the court order restraining the payment due to family dispute. So, since the court has declared due to operation of law, you are not able to declare. You are trying to declare, but court order is restraining you from giving the dividend to successor. So that is why, based on the operation of law, you are not required to pay the dividend. So that is why there will be no punishment. That's all. You followed the court order. There's no delay on your part. That's what you have to write down. You have to write down about section 127. What will be the provision here? So, punishment to failure to distribute the dividend on time. One of situations where the shareholder has given directions to the company regarding the payment of the dividend and those directions could not be complied, but the non-compliance was not communicated. This communication is the problem for us. Are we clear with this? So in the given situation, company has failed to communicate to the shareholder about non-compliance of her directions. Therefore, the penal provisions of section 127 will be applicable. And section 127 provides that no offence shall be deemed to have been committed where the dividend could not be paid due to the reason of operation of law. Here also, since the court has declared until the resolution of the succession, you don't need to declare. So that is why here you are following the court's order. There will be no penal provisions. So hence there will be no liability on behalf of the company or the directors. I hope I'm clear. So, ma'am, what if the company does not communicate to the shareholders, then it is a default? Yes, it is default. That is what it is, a default. Are we clear with this? And I would recommend the students to also learn the penalty of dividends. For only dividends you learn the penalty, because it's the only section which will be asked most probably. 127 will only be asked. So what will be the punishment for the director? Director imprisonment may extend to 2 years and the penalty will be 1,000 for every day. Simple, what do you say? Penalty, imprisonment 2 years, everyday penalty will be 1,000, and punishment for the company will be 18% simple interest. This is recommended. Why? Because it can be asked, because most of the attempts penalty has been asked. Are we clear with this? So what is a penalty? For director, imprisonment 2 years and 1,000 for every day till the default continues. And for the company has to pay a simple interest of 18% per annum. That's all. So let's get back to the third unit. So third unit, this is a direct question. First question, ma'am, even if the company has communicated and the shareholders does not respond, is the company liable? No, company is not liable, because company has given the communication to the shareholder. So company is not liable. Clear? So let's move on to the next question of unit 3. Ravi Limited maintained its books of accounts under single entry system of accounting. Is it permitted under the provisions of Companies Act 2013? So section 128 is saying that every company has to prepare books of accounts and it has to be maintained by portraying true and fair view, and it has to follow 2 things: accrual basis and double entry system of accounting. So can it maintain the books in single entry system? No, it is not permitted. Next question. State the persons responsible for complying with the provisions regarding maintenance of books of accounts of the company. So, maintenance of books of accounts, everything is discussed under 128. At the end of 128, who are the personnel in the company who are responsible for satisfying the section 128? So, who are the persons? First, managing director and whole-time director in charge of finance and chief financial officer. If these three persons are also not available, then any person charged by the board of directors to comply with section 128. So these are the persons responsible. Who are the persons responsible? Once again, we'll revise. Managing director, whole-time director in charge of finance and chief financial officer. If these three parties are also not available, then any person authorized by the board of directors. That's all. And the third question, whether a company can keep books of accounts in the electronic mode accessible only outside India. This is an important question. So, if company is maintaining the books of accounts in the electronic form, it has to follow few rules. And they should be accessible in India. Backup should be maintained in physical servers located in India. So let's see the rules for maintenance of books of accounts in the electronic format. So, a company has the option of keeping such books of accounts or other relevant papers in electronic mode. So, the books of accounts and other relevant books and other relevant papers maintained in electronic mode. First and the most important requirement, people in India should be able to access those records for subsequent reference. If you want to refer to the books of accounts for a transaction, it should be accessible in India. Next, you should follow the original format for storing in the electronic format. The original format should be complete and unaltered. From physical to digital, when it is being converted, you have to make sure it's in original format, complete and unaltered. And the next one, from the branch also, whatever is received from the branch office, that branch accounts also should not be altered, and it should be displayed in legible, easily understood format. That's a legible format. And since it is in the digital format, whatever the software that you are using, that software should have storage facility, retrieval, that is to take back the records, display and print out. And servers should be physically located in India. Backup you will maintain for your WhatsApp chats. Here also backup should be maintained for every day's accounting transactions. That backup should be present daily basis. You have to update in physical servers located in India. Are we clear with this? So to answer the question, company cannot keep books of accounts in the electronic mode accessible only outside India. It should be accessible in India. Are we clear with this? That's all. Now, question number 2 under accounts of companies. So, this is regarding signing of financial statements, the most important from a case study MCQ point of view. Okay, let's see. Board of Directors of Vishwakarma Electronics Limited consists of Mr. Ghanshyam, Director. So, one of the person is, let's highlight, Mr. Ghanshyam, who is a normal director. Next, Mr. Haider, who is a normal director. Now, Mr. Inderson, who is a managing director. Now, the company has also employed one more person is there. Who is this person? Company secretary. So, the financial statements of the company was signed by Mr. Ghanshyam and Haider. Now comes the question, who signed? Mr. Ghanshyam, normal director. Mr. Haider, normal director. Before we conclude whether it's valid or not, first you have to see who has to sign. This is section 134. Who has to sign the financial statements? First person. Chairperson authorized by board of directors. Chairperson is not available or chairperson is not authorized. Then replacement for chairperson, who has to sign? Two directors, out of which one should be a managing director. One should be a managing director. Well and good. Now, other than these persons, who else has to sign? CEO, CFO, CS. Other than this, compulsorily who else has to sign? CEO, CFO, CS. Are we clear with this? Now, in our example, in our question, CEO and CFO is not there. Clear, babies? They are not here. So that is why who else is there? Company secretary is there. Now comes the question, who has to sign? Check the case law. Is there a chairperson mentioned here? There is no chairperson mentioned. So who has to sign? Two directors, out of which managing director should sign. Now here, managing director Mr. Inderson must definitely sign. Did he sign? No. So is the authentication valid? Answer is no. And there is also a company secretary. He should also sign. Clear with this? That is what you will write down. First, write down regarding the provisions. Chairperson or else two directors, out of which one shall be managing director, and also CEO, CFO and company secretary. In one person company, there is only one director. Then only one person has to, that one director has to sign. Now let's see in the instant case, balance sheet and profit and loss account have been signed only by Mr. Gansham and Mr. Haider, the directors. In view of section 134 of the Companies Act, Mr. Inderson, the managing director, should be one of the two signing authorities. Who else has to sign other than Haider and other than Gansham? Inderson. Why? Because he is a managing director. Clear with this? So, and company has employed a company secretary, so he should also sign the financial statements. Therefore, the authentication is incomplete and non-compliant with section 134. Are we clear with this? I hope so. One managing director at least. Well and good, my dear students. I hope you're slowly able to recall some of the other provisions. Yes. So, this is the MQP question which was asked in the June 2026 MQP related to the corporate social responsibility. I am predicting this question can be asked in the final exam. Okay, so listen very carefully and read it with me. Firstly, corporate social responsibility section is 135. Yes or no? Now, firstly, which classes of companies must form CSR committee? 3 threshold values you have to satisfy. First, net worth. How much should be the net worth? Minimum 500 crores. Turnover should be minimum 1000 crores. And net profit should be minimum 5 crores. Are we clear with this? Now, any one condition can be satisfied. All these conditions should be satisfied for which year? Immediately preceding financial year. Clear with this? So, let's read the question. Corporate social responsibility is a crucial component of modern corporate sustainability. Discuss the statutory applicability criteria for consulting a corporate social responsibility committee, constituting under section 135 of the Companies Act. Furthermore, align any 4 core functions, duties that the CSR committee is mandated to perform once constituted. What are those mandatory core functions? Nothing. They have to form. After forming, they have to formulate the CSR policy. Yes. They have to fix the remuneration, expenditure for what are the CSR activities they have to implement, that has to be decided. Who will monitor, that has to be decided. So 4, done. Clear with this? So first you have to write down what is the statutory requirement mandated for them to form the CSR committee. Now, the functions. First, they have to formulate CSR policy. Next, they have to recommend the expenditure and they have to monitor the policy and they have to formulate the annual action plan, which project they have to implement for this year. So, all these plans also was to formulate CSR committee. By mistake also don't write down all the provisions, 2%, ongoing provision, ongoing project, transfer to the fund. All these provisions are not mandatory. They have asked core functions of the CSR committee. Are we clear with this? Now, listen to this. The CSR committee is mandated to perform the following statutory functions. First, formulate CSR policy. Clear with this? Formulate and recommend to the board a corporate social responsibility policy which shall indicate the activities to be undertaken by the company as specified under Schedule 7. We also know the Schedule 7 has the activities. That question is also there in our syllabus. Yes. Now, recommend expenditure. So, we know the expenditure is 2%. So, they can decide how much amount they want to recommend. Next, monitor the policy. Institute a transparent monitoring mechanism so that are they implementing the projects or not. Someone has to monitor. That monitoring policy should also be there. And formulate an annual action plan. So annually, what projects has to be taken into consideration, so how, in what ways you have to utilize the fund, and who will assess the impact, whether it is actually benefiting the person or not. All this monitoring as well as the action plan should also be formulated by the CSR committee. Are we clear with this? Now, let's say if section 135 is applicable for the company, then for the next 3 years no limit cross for CSR. B, do CSR expenditure in 4th year are not required to follow section 135. I did not understand your doubt, my dear. Please ask once again clearly. So till now everything is clear, my dear. Yes or no? Be unique. Ma'am, in dividend question, surplus treatment, please explain. Surplus also you will use for the purpose of dividend declaration. Actually, the surplus should be transferred into free reserves, but it's left out as a credit balance of P&L that will also be used as a profit first. Are we clear with this? Until unless it's transferred into free reserves, you will not consider it as free reserves, but you will be using for the purpose of the declaration. I hope I'm clear. Next, thank you. Thank you so much for the session. You're welcome, my dear. What if it's a net loss? Then you have to set off the loss with whatever you have withdrawn. Let's say in the year 25-26 CSR committee applicable, then for the next 3 years company is out of the limit. This company required for CSR expenditure in the 4th year. That's actually so you are telling if the company continuously for 3 years is not able to satisfy this 500 crores, 1000 crores and 5 crores, can the company is required to constitute CSR committee for the 4th year, or you have to incur the expenditure for the 4th year? So the answer will be no. But there are slight amendments also. So but one more thing that I have to clarify regarding that provision is it's not there in our syllabus. So you don't need to get into deeper conditions regarding that, but answer is no. Okay, so let's continue. Ma'am, by doing important questions, at least how many marks of descriptive we can attempt? Nice question. At least if you check around 50 marks you can easily attempt, my dear. But of course you should be confident enough. It's not like exactly what's there in my important questions PDF should come in the exam. So concept will definitely come in my opinion. Why? Because there are almost 95 questions in the new PDF. So out of that, at least I expect at least 40 marks should come at least, like to the least. Okay, so remaining also you can do it on your own. So based on this, they have given one question. So firstly, they have given the values regarding the corporate social responsibility. Do the company comes under the CSR obligation? If you check the latest 2020-2021, in this the limit of turnover is crossed, as well as the net worth is crossed, and as well as the net profit is crossed. Here also net profit is crossed, here also net profit is crossed, here also net profit is crossed. So of course it is required to form CSR. Are we clear with this? Now, is CSR committee required? Answer is yes. If it is under the obligation, CSR committee is also required. What are the other obligations under the CSR committee? So other obligations will be to formulate the CSR policy, and you should also file the form CSR 1. And what will happen if the stipulated amount is not spent within the year? It will be transferred into the specified fund of Schedule 7. And what will happen if the project is taken up but the full allocated amount is not spent? It will be transferred into the fund called the unspent CSR account. That's all. So first, will it come under the obligation? For the year 2021, the company's turnover is 1000 crores, 1010 crores, which exceeds 1000 crores threshold. Therefore, ABC Tires comes under CSR obligation. Now, yes, the CSR committee is required to be formed, as it comes under the purview of Section 135. And what will be the other obligations? It should spend at least 2% of the average net profits in the immediately preceding 3 financial years. And other obligations will be to spend the amount within the financial year. Details you have to disclose in the board's report, and form CSR 1 has to be filed. So what are the 3 other obligations? Spend 2%, disclose in board's report, and form CSR 1. Clear? Next, the amount unspent will be transferred to a special account as specified under Schedule 7. You can write down the Schedule 7 or not. And if the project is taken up and the full amount is not spent, the amount shall be kept separately for financing, which is called as the ongoing account, or also called as unspent corporate social responsibility account. Ma'am, in version 6 some questions are not included. Does that mean those questions are from MQP? Yes. For example, this question is not there in version 6. Why? Because it is MQP June 2026 question. Ma'am, in today's session we will cover all questions, or will there be any session tomorrow as well? So today I've already given you the update at the beginning itself. I will be covering detailedly all the questions of the Companies Act. I will just give you an overview of the questions, of what questions are there in the economics law as well as the IBC and corporate governance, because all those are pure theory questions. Okay, so today only. Tomorrow will be case study based question, case study MCQs, that I will take a live. Clear? So we have completed this question also. Now we'll move on to question 13. Okay, what kind of question is expected from IBC? We can't expect any question for sure, but case study based MCQ, a case study based question can come. Okay, so let's start. The Government of India is holding 51% of paid up share capital of Sun Limited. So 51% is held by whom? Government of India. Okay, so now it is considered as a government company. Now the audited financial statements of Sun Limited for the financial year 22-23 were placed at the annual general meeting held on 31st August 2023. AGM is held on 31st August 2023. However, pending the comments of the Comptroller and Auditor General of India. Since it's a government company, we also need the comments of CNAG on the auditor's report. But the comments are pending. Okay, that means, can you finalize the financial statements on the date of AGM? You can't. What will happen? The meeting will be adjourned. Now, see, on the said accounts, the meeting was adjourned without adoption of accounts. Accounts are not finalized. Accounts are not adopted. Now comes, on receipt of CNAG comments on the accounts, The adjourned annual general meeting was held on. So they have held the meeting, adjourned meeting on 15th October 2023. Whereat the accounts were adopted. So finally the accounts were adopted on what date? 15th October 2023. Whereat the accounts were adopted. Thereafter, Sun Limited filed its financial statements relevant to the financial year 22-23 with the Registrar of Companies on 12th November. This is what is relevant for our question. 12th November. What is this provision? What are they trying to ask? If you see the question, you will understand. Examine with reference to the applicable provisions of the Companies Act whether Sun Limited has complied with the statutory requirement regarding filing of accounts with registrar. So here what they are asking is, since the date of AGM, immediately within 30 days of the date of AGM, you have to file the financial statements with the ROC. Are we clear? So here they are asking whether that filing of financial statement is done. Is the time limit followed? That is what they are asking. Firstly, this is section 137. What is section 137 saying here? First, check the date of original general meeting. On the date of original general meeting, let's say the accounts are adopted, then within 30 days you will file it with the ROC. Now, case 2, accounts are unadopted. If accounts, just a minute, sometimes if accounts are unadopted, then what happens? Immediately within 30 days of original meeting, you have to file it with the ROC. But how? As provisional records. These are not final. But we have conducted AGM. We will submit the finalized accounts after we conduct adjourned meeting. For now, these are our accounts on provisional basis. That is what you have to do. What is your first requirement if the accounts are unadopted? Within 30 days of the original meeting, you have to file as provisional records. After that, you will be holding adjourned meeting. Yes or no? Adjourned meeting, you have adopted the accounts. So, if adjourned meeting also you have adopted the accounts, then within 30 days, you have to file it with the ROC as final adopted records. Clear? So, in this case study, Sun Limited has to do two things. Since the accounts are not adopted at the original AGM, two things has to be done. What are the two things here? First, on provisional basis within 30 days of 31st August, they have to file. Next, within 30 days of 15th October, they have to file as final basis. Two things. But what they have done? They have only followed the second case. Second case is nothing but after the adjourned meeting, after they have adopted, within 30 days they have filed. Yes or no? 15th October, within 30 days, 12th November only they have filed. But did they file it on provisional basis? No. So they failed to follow section 137. That is what you will write down over here. So we will read the sentence. Where the financial statements are not adopted at annual general meeting or adjourned annual general meeting, such unadopted financial statements along with the required documents shall be filed with the registrar within 30 days of the date of annual general meeting. The registrar shall take them in as provisional till the financial statements are filed with him after their adoption. Are we clear with this? So, let's say the financial statements are adopted in adjourned meeting, then you have to file it with the registrar within 30 days from the date of adjourned AGM. Now, what happened in the present case? In the instant case, the accounts of Sun Limited were adopted in adjourned AGM held on 15th October. So, filing of financial statements with the registrar was done on 12th November, which is 30 days, within 30 days, that is fulfilled. But Sun Limited has not filed its unadopted financial statements within 30 days of the annual general meeting on 31st August 2023. Therefore, it has not complied with the statutory requirement regarding the filing of unadopted financial statements with the registrar, but has certainly complied with the provisions by filing adopted accounts within due date with the registrar. So, there is a non-compliance regarding part of the provision. Ma'am, in economic loss, for now, if you don't have any other option left out, you have to rely on this only, my dear. Ma'am, can you please explain the unspent amount of CSR time limits? Okay, sure, I'll explain that. Ma'am, only Company Act will be discussed, or other chapters also. Company Act I will discuss in detail. Other chapters, quickly I'll revise. Yeah, it's sufficient, my dear. For now, it's sufficient. You have no other option at the end. Clear with this? I will discuss SEBI also, no worries. Unspent amount of CSR. Let's say if the unspent amount is related to ongoing project. Project is going on. This year you are not able to complete the project. At the end of the year you have some unspent amount, but the project is also not completed. So this amount is related to what? That particular ongoing project, yes or no? So that is why this amount you will transfer into an account called as unspent CSR account, which is used for ongoing project. And this ongoing project, for that, within how many years you have to spend that unspent CSR account? Within 3 years. Are we clear with this? So, ongoing projects transfer to unspent CSR account. Within what is the time limit to transfer to unspent CSR account? 30 days. Clear with this? Now, shall be used for the purpose of, that will be used only for the purpose of ongoing project. Within how many years? Within the next 3 years. After 3 years also, if there is any amount left out in the unspent CSR account, that will be transferred to a fund specified under Schedule 7. What is the time limit here also? Within 30 days from the end of third financial year. If it is ongoing project, both the cases 30 days, 3 years. But if the project is completed, you have fund left out, then what happens to that money? That will be transferred directly to the fund specified under Schedule 7. Time limit is 6 months. Clear with this? I hope so. Ma'am, if the company has no profits and they have set off the losses, the company have already declared the dividend, as they don't have any profits or free reserves to distribute dividend, has no profits, they have set off the losses, company has already declared the dividend. So that is what it's very important. Company has no profits, yes or no? First it has to withdraw from free reserves. So that is why it should make sure all the conditions are satisfied, then only it has to declare. It has to decide the rate, it has to decide the amount, it has to set off the losses. Whatever is left out, then only they have to make a commitment. If they make a commitment, even if company is in losses, even if company has no free reserves, it should still make the payment. That is why before you make the commitment, you have to satisfy these conditions. Ma'am, from where? Tomorrow only I will share the PDF for case study based MCQs. Okay. So let's continue. We are done with the unit 3 also. Now we'll start with unit 4, audit and auditors. Okay. So unit 4, audit and auditors. Let's start with the first question, which was asked in June 2023, past question for 10 marks alone. So Mr. Ravinder Nath is a managing director of ABC Limited. Now the audit is going, and there are many issues which the auditor has pointed out. The same are being clarified by the company management. They have issues, the auditor is pointing out, and the management is clarifying. But auditor is not satisfied. He is not satisfied with the explanations. Now managing director wants to consult you. You have to give advice to managing director. Consult you as the CFO of the company. Finally, you have become the CFO of the company. Okay, on how the current auditor can be removed. So they are asking removal procedure. So what's the removal procedure? Firstly, you have to pass a special resolution. Before you pass special resolution, what is the procedure? First, pass a board resolution. Within 30 days of board resolution, send ADT 2 to the central government. Central government will send approval. Now within 60 days from the date of receipt of approval, you have to conduct a general meeting. In the general meeting, first give a reasonable opportunity of being heard for the auditor and then pass a special resolution. This is the process. Clear? Let's continue. Auditor is also not feeling comfortable and has threatened to resign. Auditor has threatened to resign. Now please advise MD on the legal provisions under the Companies Act 2013 in respect of the following. First question. Can the auditor be removed? Please state the procedure. Can the auditor be removed? Yes. What is the procedure? By passing a special resolution. But after that, before that, you have to obtain previous approval of central government, and you should also give a reasonable opportunity of being heard. And you will file an application to the central government in which form? ADT 2, and the application shall be made to the central government within 30 days of the resolution of board meeting. So if you talk about the actual process, first will be board meeting. Within 30 days, ADT 2 to central government. Next, central government approval will be given. Now, within 60 days of the approval, you have to conduct a general meeting, and in this general meeting, you have to pass a special resolution. Before passing special resolution, you have to give a reasonable opportunity of being heard. This will be the procedure. Clear with this? That's all. Now, second, as the auditor is not satisfied, what if he resigns? What if he resigns? If he resigns, then he has to file ADT 3, removal ADT 2, resignation ADT 3. Clear? So under section 140, if the auditor has resigned from the company, he shall file within 30 days from the date of resignation a statement in the form ADT 3 to the company as well as to the registrar. And if it is a government company, he should also file it with C&AG. And of course, he has to give reasons for his resignation. And the last question, if auditor decides to continue with the assignment and he issues a qualified report means there is a possible chance of misstatements in the financial statements. Clear with this? That means auditor has seen some or the other frauds or misstatements in the financial statements. Clear? On the observations found by him during the course of audit, the same will be disclosed and the same explanation will be given in the board's report. Clear with this? If the auditor gives a qualified report, the same has to be replied by the board of the directors as annexure to the board's report, and this shall be circulated and placed in the annual general meeting. Are we clear with this? That's all. This is the first question. Ma'am, can we write this answer according to the series of activities? Absolutely yes. You can write down based on the series of activities also. Clear? But again, I'm telling you, underline red highlighted words. Please watch the presentation guidelines video in my playlist. That will really help you and get the actual essence of what has to be written, how has to be written. So, next question, this is regarding disqualifications of auditor. I hope everyone is following along. You should be doing the preparation with me. We already completed 3 units. Now we are in the 4th unit. Okay. So, examine whether the following persons are eligible for being appointed as auditor under the provisions of the Companies Act 2013. First case, you have to simply say qualified or disqualified. That's all. Okay. So, first, Mr. Prakash is a practicing chartered accountant and ma'am, please confirm about political contribution. At the beginning of the session only I have given confirmation. Just Go back at the beginning itself. So, Mr. Prakash is a practicing chartered accountant and Mr. Akash, who is a relative of Mr. Prakash. Akash is relative. Relative is holding the securities of ABC Limited, having a face value of 70,000, market value of 1,10,000. Directors of ABC Limited wants to appoint Mr. Prakash as an auditor. So, if the person, relative, partner, if they are holding security in the company, holding, subsidiary, associate, subsidiary of holding company, then the person will become disqualified. But relative can hold up to rupees 1 lakh face value in the company. Clear with this? So here how much face value if the person is holding? 70,000. Who is holding? Auditor or relative? Relative. So is the person qualified or disqualified? He is qualified. Next. Mr. Ramesh is practicing chartered accountant indebted to MNP for rupees of 6 lakhs. Director of MNP wants to appoint Mr. Ramesh as auditor. Again the same thing. Person, partner, relative. They should not be indebted to the company, holding, subsidiary, associate, subsidiary of holding company in excess of 5 lakhs. Up to 5 lakhs allowed. But if it is exceeding 5 lakhs, you will become disqualified. So here in our question, the amount is 6 lakhs. So the person is disqualified. Next, Mrs. KVJ, spouse of Mr. Kumar, a chartered accountant. Mr. Kumar is chartered accountant and his wife is Mrs. KVJ. Now, this wife is a storekeeper of PRC Limited. Storekeeper means employee of PRC Limited. Now, directors of PRC Limited wants to appoint Mr. Kumar as an auditor of the company. Firstly, we'll see the disqualification. Directors, relative, cannot act as auditor, but employee's relative can act as auditor. So here the auditor's relative is that person. Is the person a storekeeper or a director? She's just a storekeeper. So that is why Mr. Kumar is qualified. But imagine Mrs. KVJ being a director or KMP, then the person will be disqualified. That's all. So according to section 144 of the Companies Act, please listen to this. Person, relative, partner. Every single sentence holds marks in the key. What is that? First, you can't just write down person. You have to write down person, relative, partner. Holding security. Not you can't just conclude in the company. You have to write down company, subsidiary, holding, associate, subsidiary of holding company. For this, they can give in the key 0.5 mark or some or the other amount of marks. So you have to be very careful when you're writing the provision. Make sure everything is written. Clear? Which carries voting rights. Such person cannot be appointed as an auditor provided. What is the exception? Relative of such person may hold interest in the company face value not exceeding 1 lakh. Maximum 1 lakh face value. But in our case study, it's 70,000. So this person is not disqualified. That means he is qualified. Next, person is disqualified to be appointed as an auditor if he or his relative is indebted to the company, subsidiary, holding, associate, subsidiary of holding company in excess of 5 lakhs. So here in this case, they are indebted for 6 lakhs. So that is why that person will be disqualified. Clear with this? Next, third case, according to section 144, a person is disqualified to be appointed as auditor if his relative is a director. Now, his wife KVJ, is she a director? No, she's just an employee. So that is why is an employment of the company as a director or KMP. Normal employment is qualified. As a director or KMP, disqualified. So in the instant case, this Mrs. KVJ, spouse of Mr. Kumar, is a storekeeper of PRC. Mr. Kumar will not be disqualified. Thank you. Next, moving on to question 16. I think this is okay. 2 more questions under unit 4. Then we can start board of directors. Okay. So, Mr. Faithful is an auditor of Daga Limited. While auditing the accounts of Daga Limited for 2016-17, he finds manipulation of fund of rupees 2 crores committed by the officers of the company against Daga Limited. Now, they are asking you to write down regarding the treatment of frauds. Once again, if the fraud amount is less than 1 crore, you will just report it to board of directors. But if the fraud amount is more than or equal to 1 crore, you will report to board of directors, take their reply, and you will report it to central government in the form ADT4. That's all. Okay. So, good evening, Navneet. How are you? How's the preparation going on? So, Mr. Faithful is an auditor of Daga Limited. So, that person is an auditor and the fund fraud is 2 crores. So, that is why, as per section 143 subsection 12 of the Companies Act, if an auditor of the company in the course of his performance of his duties as auditor has a reason to believe that an offence of fraud involves or is expected to involve 1 crore or above, then it's being or has been committed against the company by its officer or employees. Then auditor has to report the matter to central government. What will be the process? First, report to board of directors. Within how many days you have to report? 2 days. Immediately, but not later than 2 days. Now, board of directors will give a reply. So, how many days are available for the board of directors to give reply? 45 days. If a reply is not received, then within the expiry of 45 days, the person has to file ADT 4 to central government, and reply is received within 15 days of reply received. ADT 4 has to be filed with the central government. This is the procedure. Are we clear with this? So let's see the procedure in sentence format. Auditor shall report the matter to the board or the audit committee as the case may be immediately but not later than 2 days of his knowledge. Seeking a reply, how many days are available for the board of directors to reply? Within 45 days. Now, on receipt of such reply or observations, auditor shall forward his report, that is the reply and observations of the board or the audit committee along with his comments to central government within 15 days. If you receive the reply within 15 days, you have to send ADT 4. Now, in case auditor fails to get any reply or observations of the audit committee or the board of directors within the stipulated period of 45 days, then he shall forward his report to central government along with a note containing that we did not receive any reply. Clear with this? Now, report shall be filed electronically in the form ADT 4. That's all. In the report, what you will disclose? Board's report. In the board's report, what you will disclose? Nature of fraud, approximate amount involved, parties involved, and remedial actions taken. Clear with this? That's all. We are done. And the last question of audit and auditors. I'm not going to read the questions. This is regarding section 144. What all services will quickly revise? What should not be rendered by auditor? Auditor has to render any service approved by board of directors or audit committee. But board of directors or audit committee should not request or approve what services? First, accounting or bookkeeping services. Second, internal audit. Third, design and implementation of financial information system. Fourth, actuarial services. Actuarial services means estimating loss, estimating risks. Clear with this? Next, investment advisory, investment banking, and rendering outsourced financial services, management services. So overall, we have 8. So these 8 should not be rendered by the auditor. So he should not take up the request and he should not render such services. That's all. So shall we start unit 5? Everyone is clear for the first 4 units? Yes or no? Please let me know. Okay, let's start with unit 5. So, Mirinda Limited is an unlisted company with a paid up capital of 40 crores. This is rupees, just correct it. And turnover of rupees 350 crores. Okay. So, before we get started with the question, what is the paid up share capital? 40 crores. And what's the turnover? 350 crores. Since it's the director's chapter, clear with this? Firstly, what is required if it's a public unlisted company and the paid up share capital is more than or equal to 10 crores? At least, just a minute. At least 2 independent directors should be appointed. And if the turnover is more than or equal to 300 crores or paid up share capital is more than or equal to 100 crores, at least 1 woman director has to be appointed. So, here, even if paid up share capital requirement is not satisfied, turnover is more than 300 crores. So, that is why at least 1 woman director has to be appointed. Clear with this? Now, both the requirements should be satisfied. Ma'am, can you be a little slow in director? Sure, I'll be a little slow. No problem. Suguna Balamurugan. Hi, madam. You are revising along with me. That's very nice of you. All the very best. So, let's continue. So, paid up share capital is 40 crores. So, independent director 2 they have to appoint. Next, turnover is more than 300 crores. So, at least 1 woman director has to be appointed. Now, first, based on these 2 requirements, let's see who are the directors in the company. First, Mr. Rajiv Mishra, who is a promoter and managing director of the company. Okay. Can you, so he is not a woman director. And he is the promoter. Can a promoter be considered as an independent director? He is not an independent director. Next, Preetham, Mr. Preetham is the non-executive chairman. Here also they have not directly given whether the person is independent director or not. We have to take an assumption here also. Okay, since he is a non-executive chairperson, we can consider him as independent director. But of course, this is again assumption. Clear? Next, Mr. Charan Chadda, Director of Finance. If he is a whole-time Director of Finance, he can't be considered as an independent director. Again, clear with this? So, of course, I will not consider him as an independent director. Next, Mr. Anurag Sinha, Director of Operation is related to promoter. If he is related to promoter, of course, he is not an independent director. And Miss Supriti, Company Secretary. She is a company secretary, not a director. So, that's why you will not consider this person as a woman director. Okay. If you have faith, you can easily score 60. Okay. So, company is in the plan for expansion and therefore wants to avail sizable loan from a nationalized bank. Company wants to loan from a nationalized bank. Well and good. The bank wants to nominate a person. So, bank wants to nominate a nominee director. Okay. Well and good. Can they do it? Yes. Now, MD seeks your advice on the following points. First point. Is the present board properly constituted? Do you believe the board is properly constituted? 1 woman director should be there. Is the 1 woman director there? No. 2 independent directors should be there. 2 independent directors are there? No. So, is the board properly constituted? No. If not, what is non-compliance? Non-compliance is regarding 2 aspects, independent director and woman director. Next, can Mr. Anurag Sinha be considered as independent director? Who is this fellow? Anurag Sinha is related to promoter. So, of course, you will not consider him as independent director. Clear? Next, third question. What will be the status of the director if nominated by bank? If bank is nominating that person, he will be considered as nominee director. Okay. Second part of the question, if the said nominated director is a woman, the nominee director is a woman. Clear? So, would she satisfy the requirement of woman director? Answer is yes. If the nominee director is a woman and she is appointed, she will be considered as fulfilling the mandatory requirement of one woman director. This is what is a suggested answer and this is what is the appropriate answer. Are we clear? So she will be considered as a woman director, fulfilling the condition. Next, is there any requirement of CFO? As per section 203, every public company with a paid up share capital of rupees 10 crores or more must appoint whole time KMP. In that whole time KMP, one of the KMP is Chief Financial Officer. Since the paid up share capital is more than or equal to 10 crores, of course CFO is required to be appointed. Are we clear with this? So, that is what you will write down over here. First, compliance. You have to write down about the case study and write down about the requirement of independent director. So, which class of companies must appoint independent director? Every listed company must appoint at least 1/3 of the independent directors out of the total strength of the board of directors. When it comes to other cases, unlisted public companies shall appoint at least 2 independent directors if any one of the 3 conditions is satisfied. What is the first? Paid up share capital 10 crores or more, turnover 100 crores or more, outstanding loans, debentures, deposits more than 50 crores. Clear with this? And also, women director is required for which class of companies? Paid up share capital 100 crores or more, turnover 300 crores or more. Therefore, Mirinda exceeds the turnover thresholds of 100 crores, so it requires at least 2 independent directors from the given data. There is no mention of any independent director. So, there is a non-compliance with the requirement of appointing independent director. Here also, additionally, such company must appoint at least 1 woman director. So, there is no mention of woman director. So, there is another non-compliance. The board is not properly constituted. Clear with this? Yes. Next. Second, can Mr. Anurag Sinha be considered as independent director? No, Mr. Anurag Sinha cannot be considered as independent director because he is a director of operation and related to promoter. Clear with this? So, which disqualifies him under the definition of the independent director under section 149. Now, director nominated by the bank will be classified as nominee director. Yes or no? Now, if the nominated director is a woman, she can be regarded as a women director required under 149. If appointed as per the rule 3. Rule 3 means DIN requirement, consent, all this also needs to be complied with. And the last question is regarding CFO. Ma'am, one question: in case of independent directors with all the 3 conditions must be fulfilled, like turnover, any one condition, not all the 3, any one condition. If one condition satisfies also, you have to appoint independent. That's why we will be using the word or. Clear? Last, CFO, as per section 203 of the Companies Act, as per the rule 8 of the Companies Act, every listed company and every other public company having a paid up share capital of rupees 10 crores or more shall have whole time KMP, including CFO. That is why CFO is to be appointed as KMP since paid up share capital is more than 10 crores. So there is a requirement of CFO. Yes, more than or equal to. But when it comes to 50 crores of outstanding loans, deposits and debentures, it should be more than 50 crores. Yes, independent director requirement is 149 subsection 4. Qualifications is 149 subsection 6. Thank you, Prasad. Let's move on to the next question. ADJ Limited has 10 directors on its board. How many directors are there total? 10. 2 directors have retired by rotation. So out of this, how many have completed their retirement? Two directors have retired. Clear with this? Now, the place of retiring director is not so filled up in the AGM. Retirement is completed. But did they fill the position? No. The meeting also not expressly resolved not to fill the vacancy. What is this concept? Not to fill the vacancy. So 10 directors are there. 2 positions vacant. How many are remaining? 8 directors are remaining. As per the minimum requirements of the directors in public company, since it's a limited company, public company, how many minimum number of directors should be there? Minimum only 3 should be there. But how many are there? 8 are there. So can they decide that we will continue with 8 directors, we will not fill the vacancy? Yes. But did they decide that? They did not decide. So we are in confusion. They did not fill the vacancy. They did not decide not to fill the vacancy. Clear? Next. Since the AGM could not complete its business, decision is pending. Yes, it is adjourned till the same day, same time, same place next week. Okay, well and good. At this adjourned meeting also, the place of retiring directors could not be filled up. They are not filling the vacancy there also. And the meeting has also not expressly resolved not to fill the vacancy. Again, same pending. Adjourned meeting also they have pending. They have the business is pending. Clear with this? Now what happens? Now comes the concept of deemed reappointment. Are you able to recall? Original meeting, vacancy is not filled, not expressly decided not to fill the vacancy. Adjourned meeting also, vacancy is not filled and expressly they have not decided not to fill the vacancy. Then what happens? Automatically the person, the retiring director will be deemed to be reappointed. That's all. So now, whether in such situations the retiring director shall be deemed to have been reappointed, answer is yes. They will be reappointed. Clear? Next, what will be your answer in case at the adjourned meeting the resolutions for reappointment of their directors were lost? So, the concept here is, in the adjourned meeting or in the original AGM, already they have proposed a resolution that we are going to reappoint these people only. But they did not receive majority. So that means majority of the persons are not willing to reappoint the retiring directors. Previous meeting or in the adjourned meeting, they lost the meeting. Can you consider these people to be deemed to be reappointed? No, if they have lost. So in this case, will your answer be, what will be your answer at the adjourned meeting, the resolutions for this? Then the person will not be deemed to be reappointed. Single PDF for all the limits. We'll see. Kirti Pandey, thank you so much. Third question, whether such directors can continue in case the directors do not call annual general meeting. AGM is not held. That means if AGM is not held, I don't need to retire, I'll continue. It won't happen, my dear. You have to retire. But when? On the last date on which the AGM should have been held. Clear with this? When that person will automatically retire, even if AGM is not held, on the last date the AGM should have been held. That's all. Clear with this? So, you will write down the whole provision of 152 subsection 7. Same thing. The meeting will be adjourned same day in the next week, same time and same place. And then if the in the adjourned meeting also the vacancy is not filled and not expressly resolved not to fill the vacancy, the retiring director shall be deemed to have been reappointed at the adjourned meeting. When you can't assume deemed reappointment, if their proposal is put and lost and if they have shown his unwillingness or the person is disqualified. Clear with this? Next, therefore, in the first case, applying the above provisions, the retiring director shall be deemed to have been reappointed. In the second case, where the resolutions for the reappointment of the retiring director were lost, so the person will not be deemed to have been reappointed. Good evening, Molly. How's your preparation going on? So, next, moving on to the third case. Clear with this? Third case, AGM is not held. But for sure in every AGM, 1/3 of the rotational directors will retire. When they have to retire, last date the AGM should have been held. So further, it is necessary for the company to hold the AGM where the directors are liable to retire. So let's say the AGM is not held till the last date on which it should have been held. It should have been held. The term of retiring director ends on the last date and it cannot be extended till the new date when the AGM shall be held. Clear with this? That's all. Now moving on to question 20. So till now I hope these two are clear. Yes? Yes or no? Tripura, good evening. So I hope everything is clear till now. Let's move on to question 20. This was asked in December 2021, old syllabus, around 12 marks, one question. Okay. So Mr. Vikram, a director of Messrs. Tubelight Limited, has made a default in filing of annual accounts and annual returns with the registrar of companies for a continuous period of 3 financial years. As soon as you read this, you should understand one thing. 164 subsection 2, if a company fails to file the financial statements continuously for 3 years, then every director is disqualified. Yes or no? Now, OMR is enough. OMR is enough. No need to write down explanation. But make sure you write in OMR. If you write down in your paper and don't write in OMR, expect 0 marks. Okay? So, whether Mr. Vikram can continue to be the director of Messrs. Tubelight Limited and also Messrs. Greenlight Limited, where he is also a director. Now, let's understand the concept first. So, this is section 164 subsection 2, where it says that if a company fails to file financial statements or annual return continuously, for a period of 3 consecutive years, 3 consecutive years. Clear with this? Now, every director in the company will become disqualified. And the disqualification will be there for 5 years. So, till 5 years, he will be disqualified in all the companies and he cannot be reappointed in the original, that is a defaulting company or any other company for a period of 5 years. Clear? But comes the doubt. In defaulting company, who has the responsibility to file the financial statements or annual returns on behalf of the company? Board of directors. Yes or no? If they will vacate the office, who will fulfill the criteria? Directors only. So that is why they can't be reappointed in the defaulting company, but they have to resolve the issue first in the defaulting company. So that is why they will not leave the company immediately. Which company? Defaulting company. Clear with this? So they will not vacate the defaulting company immediately, but other companies they will vacate. Clear? So that is why, to answer the question, since the defaulting company is Tubelight Limited, in Tubelight Limited they will continue, but in Greenlight Limited they will not continue. Right, Navneet? So he has to leave in all the companies except in defaulting company. Correct, Somik? Yes, Rupali. Here everyone's right. So state, now second question. State whether he can be reappointed as a director in the 2 companies. No, he can't be reappointed for a period of 5 years. And what would be your answer? what would be your answer in case Mr. Vikram is a nominee director of a public financial institution? He is nominated by public financial institution. He will not become disqualified. He is an outsider being nominated by a bank based on the agreement of loan. Why will he be disqualified? Clear with this? So nominee director will not be disqualified. Next, what would be your answer in case the defaulting company is a private limited company? Now comes the question. Why? Because this section is not applicable for private limited company. Are we clear with this? So, the same thing here. So, in case Tubelight is a private limited company, according to section 164, a private company may by its article provide for any disqualifications appointed in addition. So, the answer would be same. Okay, I'm sorry, this is 164. So, it is applicable, but sorry, it's not applicable for government company. I'm really sorry. 164 subsection 2 is not applicable for government company. It is applicable for private company. Just a small confusion. So even if it's a private company also, the particular board of directors will be disqualified. That's all. Just a small confusion. Okay. So what will be your conclusion for the first case? In the first case, Mr. Vikram can continue to be a director of the defaulting company of Tubelight, but in Greenlight he cannot continue as a director. Next, here in this case, is he eligible to be appointed, reappointed in both the companies? No. So, what will be the case? Mr. Vikram will not be eligible for reappointment in Tubelight and Greenlight for a period of 5 years. And the next one, in case Mr. Vikram is a nominee director, then in such case section 164 will not be applicable. Clear with this? He will not be disqualified. Next, in case Tubelight Limited is a private limited company also, both the cases he will have to vacate from the office. Clear with this? But additional disqualifications can be added in the articles of association for private company, but public company will follow blindly 164. Okay? So, ma'am, can we mention section number only if we can't remember subsection? Yes, absolutely, you can mention subsection. Sorry, you can mention only section number, but don't write according to, just write down as per the provisions of section 164. Okay, so I hope this question is clear. Now question 21 and question 22 both are direct questions. So this is regarding 164 disqualifications. Just quickly we'll read. What are the individual disqualification? Unsound mind, undischarged insolvent, applied to be adjudicated and the application is pending, convicted for a offence by the court, less than 6 months, eligible, 6 months to less than 7 years, eligible, when if 5 years should be elapsed after the expiry of imprisonment, more than or equal to 7 years, never eligible. Are we clear with this? So, if he has been convicted by an offence, sentenced to an imprisonment not less than 6 months, less than 6 months eligible, not less than 6 months, a period of 5 years has not elapsed, 5 years should be elapsed, then he'll be qualified. If it's not elapsed, disqualified. And however, if a person has been convicted of any offence, sentenced to an imprisonment for a period of 7 years or more, less than 7 years, eligible, 5 years condition should be satisfied. Equal to or more than 7 years, he is never eligible. Clear? Next, order has been passed by the court or tribunal disqualifying him. Next, he has not paid calls for a period of 6 months and he has been convicted for a related party transaction offence in the last 5 years and he does not have DIN and he has not complied with section 165. What is section 165? This is regarding maximum number of directorships. Maximum 20 companies and in that 10 public companies. Are we clear with this? Next, this is section 164. If the company has not filed financial statements or annual returns for a continuous period of 3 financial years or has failed to repay the deposits or pay interest or debentures or dividend for a period of 1 year, then shall not be eligible to be reappointed as a director of the company or appointed in any other company for a period of 5 years. Clear with this? And if the director is just appointed 6 months ago, he will not incur disqualification. Why? Because default is happening since 3 years. I am just appointed 2 months ago. Why will I incur disqualification? Clear with this? He will not be disqualified for 6 months from the date of appointment. I hope we are clear with this. And the next question is, in which situations director position will become vacant? In which situations director position will become vacant? First, basically, if he incurs disqualification, he has to vacate immediately. But if it is 164 subsection 2, he has to vacate in all the companies except defaulting company. That's what we have studied. Yes, and he is absent for all the board meetings in the last 12 months. He has to vacate. Next, he did not follow section 184. He has to vacate. He did not disclose his interest under section 184. He has to vacate. And order has been passed by court or tribunal. He has to vacate. And he has been convicted for an offence, imprisonment not less than 6 months. Immediately he has to vacate. And he has been removed under section 169. He has to vacate. And the last one, he is holding the position in this company as a director because he is a director or he was a manager or he was some or the other officer in holding or subsidiary. Because he is a managing director of subsidiary company, he is acting as a director of holding company. If he vacates the position of managing director in subsidiary company, he has to vacate the position of director in this company also. Clear with this? So, if you still have doubt regarding this, go to the marathon. I would have explained very clearly. He, having been appointed a director by virtue of, why he is appointed? Because he is holding an office or employment in holding subsidiary or associate. Now there he is not holding. Here also he has to vacate. That's all. Last but one question, I think, last question of board of directors. Recent attempt December 2025, they have asked. Okay, so Mr. Junjunwala proposed the name of Mr. Dhanpat as director. Okay, not liable to retire by rotation. So he's not liable to retire by rotation in Vida Limited, and submitted a notice in writing on 15th July 2024 along with the deposit of 1 lakh. So one of the member has proposed a person's name to be appointed as director. What section is applicable? Section 160. Clear with this? Now, state the validity of the proposal of Mr. Junjunwala in the following situations. First, government company. But section 160 is not applicable for government companies. So that is why if Vida Limited is a government company and the government has been duly intimated. So if government has been duly intimated, you inform the government properly, you don't need to follow section 160. Next, if Vida Limited has a provision in its articles for the election of directors by ballot. So, first things first. This second exception, first exception is government company, clear. Second exception is, if the company is a section 8 company and section 8 company articles is specifying the director's election by ballot, by following a procedure of election which is ballot, clear, then section 160 is not applicable. But here Vida Limited is not a section 8 company. That is why, is section 160 applicable? Yes. How you have to elect the director? By following the postal ballot. That's all. Next, if it is a public limited company and the company has not served individual notices on the members, if you are not able to serve individual notices about this person being proposed, what you have to do is, at least you have to advertise the notice in 2 papers, English newspaper, local vernacular newspaper. But here, advertises such candidature or intention in local vernacular newspaper in the district, only local vernacular newspaper. You have to advertise in English newspaper also. Clear with this? So let's see the first point. Government company. So if Vida Limited is a government company and the government has been duly informed, section 160 does not apply to a government company. So if the ministry or the department concerned has been intimated about the proposal of the person, then the proposal is valid even without the compliance of section 160. Next, if articles provide for election of directors by ballot, so the exemption from section 160 in case of election of directors by ballot is available only to section 8 companies. If the company is a section 8 company, an article says that you have to elect the directors by ballot, then 160 is not applicable. But if it's a normal company, even if they ask for the ballot or not, the section 160 is applicable. Clear with this? So in this case, Mr. Junjunwala, since Vida Limited is a normal limited, not a section 8 company, section 160 is applicable. So you have to inform the company at least 14 days before the meeting. You have to pay the deposit. Yes or no, all these requirements must be fulfilled. So therefore, the proposal of Mr. Danpat is valid because they paid the deposit and they have informed the company in writing. So however, section 152 read with section 110, subsection 10, the appointment of directors is subject to article. So which election method you have to follow? By postal ballot. So since the articles provide the election of directors by ballot, the appointment, if made, must be decided through postal ballot. What will be your conclusion? The proposal is valid, but the appointment must be made by ballot in accordance with the articles of association. That's all. Now, it's a public company. Advertisement is made in a vernacular newspaper. Also, it should be made in the English newspaper. So where the company opts not to send individual notices, it must publish an advertisement first, at least in English newspaper and in one vernacular newspaper, and it should be published at least 7 days before the meeting. So in the given case, company has published only in vernacular newspaper, not in English newspaper, resulting in partial non-compliance. So therefore, requirement of due notice is not fully complied, hence the candidature notice is invalid and the election proceedings are irregular. So with this, we have completed board of directors also. Is everything clear till now? Yes or no? Please let me know in the comment section below. Have you revised the whole unit till unit 5 with me? Are you clear? Yes or no? Well and good. Let's start with unit 6, board meetings. Okay. So, first, 3 board meetings of A Limited were held on. So, before we start with this, as per section 173, for every company, first board meeting you will hold within how many days? 30 days from the date of incorporation. Yes. Now, subsequently, every calendar year, you have to hold a minimum of 4 board meetings. Minimum of 4 board meetings. Yes or no? Now, the gap maximum allowed between first and second, third and fourth, or second and third, maximum gap allowed will be 120 days. Are we clear? So, both the conditions should be satisfied. What are both the conditions? 4 in one calendar year. Gap maximum allowed is 20 days. 120 days. Clear? Now, we'll see the case study here. First meeting, 1st January 2022. Second, 1st April 2022. Yeah, live का video मिल जाएगा आपको. Live will be there on YouTube. You don't need to worry about. You can refer after that also. Next, 3rd meeting, 1st July 2022. And 4th meeting, initially it was scheduled on 27th October. But the quorum was not present. If quorum is not present, it will be adjourned to the same day, same time, same place next week. So, it is adjourned till 3rd of November 2022. Now, in the adjourned meeting, which is held on 3rd November, 5 matters were discussed and voted upon. So, simple. Complete. They have successfully held the adjourned meeting. Well and good. Now, you have to check. First board meeting, second board meeting, third board meeting. Gap you have to check. So don't calculate now, but in the exam you have to calculate. Here the gap is less than 120 days. Here also the gap between second and third is also less than 120 days. Now comes the question. Between third meeting and fourth meeting, what date you have to consider for calculating the gap? Will you consider 27th October or 3rd November? You will consider 27th October. Always you have to consider, for the purpose of calculation of gap, you have to consider the date of original meeting. Clear with this? Now, date of original meeting is 27th October. Now, date of adjourned meeting is 3rd November. Ma'am, what if 3rd November also the quorum is not available? Then 4th meeting is not held. Will not consider the meeting as valid. Only 3 meetings are held. Then it will be a non-compliance of section 173. But here what happened? In the adjourned meeting, meeting is successfully held. So that means you will consider the meeting as validly held. 4 meetings are conducted. Gap is less than 120 days. Gap should be counted from the date of original meeting. That's all. Old video. Bullet MCQs, old video only. Yes. So, in the present case, the board meeting held on 27th was adjourned and the adjourned board meeting was held on 3rd November. So, the meeting held on 27th and 3rd shall not be deemed as separate board meetings since an adjourned meeting is a mere continuation of original meeting. So, what date you will consider? You will consider 27th October. Clear with this? Now, the gap between first and second was not more than 120, second and third was not more than 120, third and fourth you have to consider the date of fourth original board meeting, and this is because it is considered as only one meeting, not 2 separate meetings, only one meeting. And here also the gap between third and fourth is also not more than 120 days. So therefore, A Limited has held 4 board meetings in the calendar year 2022 and the gap between no consecutive meeting is more than 120 days. So therefore, A Limited has complied section 173. Clear with this? Now moving on to the second, the most complicated question. Okay, before I start the question, just a small disclaimer I want to give you. If you still have doubts, leave this concept. Why? Because negotiations, what if happens in that situation, we have to assume this. There are a lot of complications here. I will tell you the actual provision which is applicable. You figure it out whether you understood, you want to write it or not. Clear with this? Just give me 1 minute, I'll just charge my iPad. So everyone get conscious here. Why? Because interested director. Clear with this? So, what is the required quorum for holding a board meeting as per the provisions of the Companies Act 2013? Examine the following cases in this context. First, they are asking what is the quorum as per Companies Act. What is a quorum? This is easy. We can write down 1 mark. We'll get. What is it? 1/3 of the total strength or 2 directors, whichever is higher. 1/3 or 2, whichever is higher. Clear? Now, in a board meeting, only 3 directors were present out of 11 directors. None of the 3 directors was interested in any of the items of agenda. Examine the validity of the meeting. But before you check interested director, first you have to check the normal quorum. First, what's the normal quorum? 1/3 of, how many are there? Total 11. So what is 11 of 1/3? 3.67 or 2, whichever is higher. So 3.67 will be rounded off to 4. So what is the required quorum? 4. Required quorum is 4. But how many directors are there? 3 directors. Is the meeting valid? No. Clear? Second. Now, in a meeting of board, out of total 11 directors, 5 directors were present. So, initial quorum is valid. Initially quorum is there, well and good, satisfied, super good, clear, but of which only 2 directors were not interested in one of the transactions. Okay, two directors were not interested. So here, before we get started with the provision, before we get started with the case study, we'll see the provision first. What's the provision? At any time during the meeting, if the number of interested directors is more than or equal to 2/3 of the total strength of the directors. What is 2/3 of 11? I think if you round it off, it will be 9. Yes or no? 2/3 of 11, it will be 9. Yes or no? It's better to calculate. Students, tell me, what's 2/3 of 11? It's 8. Yes, 7.33. It's 8. Okay. Super. Now, 2/3 of 11 is 8. Yes or no? So they are telling at any time during the meeting, number of interested directors is equal to or more than 8. Then 2/3 condition is satisfied. Yes or no? Then normal quorum is not applicable for the transaction. What quorum is applicable for the transaction? Special quorum. What's this special quorum? Number of non-interested directors present at the meeting, but it cannot be less than 2. Are we clear? So first, if you check the total strength, how many interested directors should be there? 8 interested directors should be there. Clear with this? But in our question, it is not clear whether 3 are interested or 8 are interested. Yes or no? Whether 3 are interested or the remaining, let's say they have specified that 2 are non-interested. So that means 11 minus 2, we can assume 9 are interested, or else 5 minus 2, 3 are interested. Yes, if you check this concept, then 2/3 condition is not applicable. 2/3 condition is not applicable. Are we clear with this? But here, if you check this case, 2/3 condition is applicable. So what you have to assume? You have to assume that the remaining 9 directors are interested. Then 2/3 condition is satisfied. Then what will be the quorum? Quorum will not be 4. Quorum will be 2. Are we clear with this? Quorum will be 2. I'm really sorry. This is MacBook. As soon as I put this, balloons will come. So I'm really sorry. Okay. So thank you. People are active. Clear with this. But what you have to think, one more concept here is, if a director is interested, director cannot participate in the meeting. Are we clear with this? So the 3 directors, whoever are there in the meeting, they can't participate. Only 2 people can participate. Who can participate? Number of non-interested directors can participate. Are we clear with this? So even if you take the assumption of 9, or if you don't take the assumption of 9, who can participate? Only the 2 non-interested directors can participate. Why? Because if you check section 184, if a director is interested, he cannot participate, he cannot vote. If the 3 persons are not able to vote and participate, how many are remaining? 2 are remaining. So these 2 persons have to continue the meeting because the 2 persons are non-interested directors. If 2/3 condition is satisfied, 2 persons can continue validly. If 2/3 condition is not satisfied, quorum is not available for the meeting, the transaction cannot take place at all. But what is the ICMAI suggested answer? They said 174 subsection 3 is applicable. So 2 directors can validly continue. So we have to assume what? Two-third condition is satisfied. How can you assume two-third condition is satisfied? Assuming the remaining 9 directors are interested. That's all. Yes, Chandu Chowdhury, I know your argument is absolutely right, but let me show you the Bare Act. So if you check the Bare Act of the Companies Act, it's very, very clear that 2/3 you have to calculate not on the directors present at the meeting. It's the total strength. So where at any time the number of interested directors exceeds or is equal to 2/3 of the total strength of the board of directors, the number of directors who are not interested and present at the meeting being not less than 2 shall be quorum during such time. Now in our case, if we assume 9 are interested, then only this is applicable, otherwise it's not applicable. Why? 5 into 2/3, what's 5 into 2/3? 4. Yes or no? 5 into 2/3 will be 4. But how many are interested? Only 3 are interested. Yes or no? So that is why it's not applicable. If you check in that point of time, it's not applicable. You should not check, because 2/3 of the total strength of board of directors. I hope I'm clear with this. First case, 2/3 will not be applicable because primarily the quorum is only not available. Primarily the quorum only is not available. Here we are talking about a particular transaction. There quorum should be there for the full meeting. Normal quorum should be there for the full meeting. Whether interested, not interested, normal quorum should be there for the full meeting. If that primary condition is not satisfied, the other conditions regarding interested, they are not applicable only. Are we clear with this? Yes or no? Please let me know. PDF is there in the Telegram channel, my dear. So that is what will be the case study over here. So based on that first case, the quorum was not present, so the meeting has not been validly held. Once more, ma'am. Sure, ma'am, I'll tell you. In the given case, required quorum comes to 4 directors, 5 were present, so the basic requirement is fulfilled. But during one of the transactions, only 2 directors were not interested. The requirement of section 174 subsection 3 is met with. Therefore, the quorum requirement is thus fulfilled. Are we clear? So the concept here is, I already told you, I'll tell you once again. 11 is the total strength. For special quorum, what's the special quorum? Number of non-interested directors, but cannot be less than 2. Clear with this? So for the special quorum to be applicable, you have to make sure at least 2/3 or more of 11, which is 8 directors, should be interested directors. Clear? So in our question, 2/3 you have to calculate from what? From 11. Next. So let's say we assume only 3 are interested. We assume out of 5, only 3 are interested. Then is section 174 subsection 3, this condition applicable? No. How many should be interested? 8 should be interested. How many are interested if we take the assumption of 3? Only 3 are interested. So is the special quorum applicable? The special quorum is not applicable. Then what quorum should be there? The quorum should be 4 non-interested directors. But how many non-interested directors are there? Only 2 non-interested directors are there. If you assume 3 are interested directors, then 174 subsection 3 will not be applicable. Ma'am, then in the meeting, how many should be there? 4 non-interested directors should be there. Quorum should be there, yes or no? Quorum is 4. Yes or no? Quorum is 4. And 4 should be non-interested because interested directors cannot participate only. 4 non-interested directors. But do we have 4 non-interested directors? We have only 2 non-interested directors. So that is why we have to take an assumption as 9 to be interested and 2 are non-interested. So 2 will participate. Meeting will be valid. Hope I am clear. Yes or no? Thank you. Yes. So, and the next question is a direct question which I am not going to revise, which is responsibilities of audit committee. What are the responsibilities of audit committee? They have to recommend regarding auditor appointment, remuneration, terms of appointment, and they have to review the auditor's work, independence, whether he is performing the audit correctly or not, and then he has to audit committee has to examine the financial statements and auditor's report, and then approval of any related party transactions and omnibus approval of related party transactions, scrutiny of intercorporate loans, valuation of undertakings, evaluation of internal financial controls, and if you have accepted any money from IPO or FPO, for what purpose you are utilizing. All these responsibilities will be of whom? Audit committee. Are we clear with this? That's all. So whatever they recommend, all these are recommendatory in nature. They will recommend to the board of directors. Board of directors will approve. If board of directors have not accepted the recommendation of audit committee, they have to disclose in the board's report. That's all. So, and can we move on to the next question? I guess so. It's also a direct question regarding the powers of board of directors. So again, I'm not going to read all this. It will be reading only. You can revise the powers of the board of directors. And the next question is also a direct question. Restrictions on the powers of board of directors. So 1, 2, 3, 4 restrictions are there. First is regarding undertaking. You have to write down the meaning of undertaking also. And second is regarding the investment of money that has been received in the form of purchase consideration for merger or amalgamation, that you have to invest in other than trust securities. If you invest in other than trust securities, you have to pass special resolution. Borrowing money exceeding the limit. This is very, very important. What is it? Firstly, it is borrowing. Okay, borrowing. Till what limit I can borrow without a special resolution? Paid up share capital, free reserves plus securities premium. Okay, if it is exceeding this value, I have to pass special resolution. Again, I am telling you, it's borrowing. Okay, that's all. And any payment from the directors, if you are giving extra time for payment, or if you are remitting, that is cancelling the payment, you have to pass special resolution. Now comes the controversial question, which is section 182, political contribution. Is everyone active? Yes or no? Shall we revise section 182 question, case study? It was asked in June 2023, old syllabus. Okay. So, Amar Cement Limited is a company incorporated 4 years ago. First of all, 2 companies cannot make political contribution. What are the 2 companies? If it is a government company and if it is in existence less than 3 financial years. Here it is in existence for 4 years and it is not a government company. So can it make political contribution? Yes. Now, it has earned amounting to 5 lakhs 8 lakhs, 11 lakhs respectively during the last 3 financial years. Now, the board of directors of the company wants to propose to donate a sum of 50,000 to a political party. First, is there a limit for political contribution? Yes, absolutely yes. As per the Supreme Court judgment, the no limit sentence is struck down. What is applicable then? Old limit only. 7.5 was there before only, my dear. 7.5 is not new limit. It was there before only. Later on, it was omitted and no limit was brought in. The no limit was struck down by the Supreme Court. Now what is applicable? Old limit is applicable. Clear with this? So what is the old limit? The political contribution for any financial year cannot exceed 7.5% of the average net profits during the preceding 3 financial years. If you calculate the average, 5 plus 8 plus 11 divided by 3, you will get 8 lakhs. 8 lakhs into 7.5%, which will be equal to 60,000. So you can make a political contribution of up to 60,000. But what is proposed in our question? 50,000. Is it as per the limit or not? Yes. What else you have to do? You have to disclose in the profit and loss statements to which political party you are contributing. That's all. How much amount? So you'll write down the provision and you have to pass a resolution in the board meeting to approve the political contribution. Now, applying the provisions, Amar Cement is not prohibited from making political contributions since it has been in existence for less than 3 financial years. For the purpose of calculation of the amount of political contribution, average net profit of the preceding 3 financial years, 5, 8, 11 divided by 3, which is 8 lakhs. What's the maximum amount? 60,000. So, accordingly, the proposal of board of directors to make donation of 50,000 to a political party is valid. Such political contribution shall be made by passing a resolution at the board meeting only. Are we clear till now? Yes. Wonderful. Last question of unit 6, which is regarding the types of registers the company will maintain. Registers regarding investments not held in the company's name, deposits, for securities bought back, for charges, regarding the list of members, the list of debenture holders, list of beneficial owners, and foreign register of members and debenture holders, and annual return copies you will maintain, as well as minutes of general meetings, minutes of board meetings, minutes of committee meetings, and register of postal ballot. So all these are the registers which are maintained by the company. Just a disclaimer, if you don't remember the form numbers, well and good, at least remember 7 registers. Deposits and investments not held already covered in unit 8. Okay, that you will remember. Other you have to remember charges, bought back members, debenture holders, beneficial owners, annual return, minutes, you know about the minutes, general meetings, and postal ballot, as well as foreign register of members. So this is the list. So every company has to maintain its register of its certain registers and records for statutory, statistical disclosure and information management and management information system (MIS) purposes. Further, the company is also required to keep these records within the vicinity of the place prescribed by for its laws. It may be maintained in the registered office or any other place decided by the board of directors. That's all. We are done with unit 6. Company formation. Will these questions be enough? Because it's very vast and vague. I know. Basically, these questions are enough. What you'll do, we can't widen our scope just before the examination. Okay? Prepare these questions. Just one time, my capsule revise if you have time. Otherwise, leave it. Okay, shall we move on? Last 4 units are left out. Is everyone attentive, active, or it's too much information at the same time? How are you all feeling? Feeling that why law is created. Of course, we don't follow the rules if they are not there in a book. So that's why law is created. Shall we start the next unit? All the students, please be active in the chat box and also simultaneously write down, revise. Yes, okay, done. Yes, full energy. Have to clear group 3. Of course, you have to clear group 3 for sure. Okay. So, unit 7. Key managerial personnel. 2 minutes break. Got sick today. Okay. You want 2 minutes break? You can have 2 minutes break. Just pause the video for 2 minutes and just... Studying is good, ma'am, but remembering is very tough. Of course it's tough. Of course it's tough. Why I remember? Because I am a law faculty. My job is this to remember. But your job is just to write the exam and pass. For that purpose, just one day, this one day try to remember however it's possible and dump it in the exam. No one will remember the whole provisions up to full clarity, and it's not humanly possible. So you will forget. It's natural. It's what happens to every student. Okay. So keep on revising many times. Just before the examination, you have to revise at least 2 times and go write down. You will remember for sure. When you see the question, automatically you will remember. And don't overthink. Initially, as soon as you read the question, what point it will strike in your brain, make sure that is the answer. You go deep thinking, then what happens is original answer you will not write down. Okay? So, yes. Anyways, we have taken 2 minutes break. Let's continue. Okay. So, there are 4 directors in Shine paper. Mr. Madhav, being the director in station, has been authorized to draw and endorse check or other negotiable instruments on account of the company, and also to direct registration of transfer of shares and signing the shares. Okay. Company has 4 directors. To one of the director, because he is in this city only, we are giving these tasks. What are the tasks which are given to this person? Draw and endorse check and draw and endorse negotiable instruments, direct the registration of transfer of shares and signing the share certificate. So these are the responsibilities which are given to Mr. Madhav. Okay. Evaluate whether he will be treated as managing director of the company. Tell me, yes or no? Whether will he be treated as managing director? Just he has the responsibility to sign, draw, endorse checks. Just these administrative activities. Will he be considered as managing director? Absolutely not. If you are just performing administrative activities, you are not considered as managing director. You should have substantial powers to influence the decisions. Take managerial decisions for the company, not just signing the documents and sending checks. That is administrative activities. Some admin will take care of it. Clear with this? So that is why in this case, since this person is performing day-to-day routine nature administrative acts, he will not get the tag of managing director. Clear with this? So also recommend the procedure for the appointment of managing director. What will be the procedure for appointment of managing director? First, he must be appointed by board of directors. What will be the procedure? First, board of directors should appoint. Then in the next general meeting, members should approve, and the person has to satisfy the conditions in 196 as well as Schedule 5. If he satisfies 196, then only he is appointed. He is satisfying 196, but he is not satisfying Schedule 5. Then one more requirement is required. That is that he needs to take the approval of central government. So this will be the procedure for the appointment of managing director. And the last procedure will be they have to file Form MR1 within 60 days from the date of appointment. So quickly we'll revise. What are the four what are the four things included in the procedure? First, approval of board of directors by passing a board resolution in the board meeting. Second, in the next general meeting, members should give approval. Third, if he is not satisfying Schedule 5 conditions, then central government's approval is required. And fourth, MR1 has to be filed. Clear with this? Now, before that, you have to write down the definition of managing director. This whole green thing is actually the definition of managing director. Don't worry. Who's a managing director? He's a director. Clear with this? And what is he having? He's having substantial powers of management. And where the powers will be mentioned? Articles or agreement or resolution in general meeting. Now, it includes directors occupying the position of managing director, whatever name. He can also be called as CEO or chairperson, whatever he is called as. Now, substantial powers of the management shall not be deemed to include. What will not be included? Administrative acts of routine nature. For example, number 1. Power to affix common seal. Number 2, draw and endorse check. Number 3, draw and endorse negotiable instruments. 4, registration of transfer of share. And next one, signing any certificate of share. Ma'am, based on past examination trends, is there any pattern regarding the acts from which questions are asked? For example, do certain acts or chapters usually not appear in the paper together in... So if you are asking me regarding, just a minute. Yes. If you are asking me regarding the, question number analysis of which chapter will come in which analysis, you can't conclude. We are not sure. Next. If you are asking me regarding the weightage analysis, if you check, if I do analysis like this, see the audit and auditor's case, it was asked in June 2023 for 10 marks. No question for the next 4 attempts. Of course, you will not study audit and auditors. What happened? December 2025, 7 marks. Only 7 marks, no ma'am. 8 marks MCQ was asked. So total 15 marks from a chapter which was not asked in the past 4 attempts. So ICMAI always surprises you in the law paper. Other papers you will not receive these big surprises. Law paper definitely you will receive because it's the first paper and they want to put down your confidence. But actual facts, if you check, at least 40 marks, 50 marks, definitely you will be able to score in the examination. That easy paper will be there. But based on 1 mark, 1 question or 2 questions or maximum 3 questions, your confidence will be gone. Looking at, oh, what is this? It's out of syllabus. Okay. So, I can't give you an analysis for sure, my dear. Ma'am, in meeting chapter, quorum plus validity of meeting in various aspects. Please cover these topics and explain past 4 attempts meeting questions because every attempt... Already I have covered meeting questions, Karthik. So, the thing is, in the meeting, they will be asking 173. Which is regarding what? 173 is regarding 4 meetings you have to hold. Maximum gap is 120. Yes or no? Now, for 1-person company, small company and dormant company, you don't need to hold 4 meetings. You need to hold 1 meeting for each half of the financial year. And the minimum gap should be 90 days. Are we clear? So, it's better I revise. Already last questions I have discussed. I'm not going to discuss additional questions, but I will be helping you with the provisions. So what is 173 specifying? First board meeting within 30 days. Subsequently, every year 4 board meetings, every calendar year, and maximum gap is 120 days. For one person company, small company and dormant company, for every half of calendar year, 1 board meeting you have to hold. Minimum 90 days gap. Clear with this? And for one person company who is having only 1 director, you don't need to hold any board meetings. And then a person can attend in-person video conferencing or audio video visuals. And this is important. Procedural aspects. Never it was asked in the examination, but it can be asked. What is it? Chairperson of meeting and company secretary should be taking care of the integrity, proper equipment is there or not, recordings are there or not, and where you have to store the recordings. Only that director is attending or some other person is attending, or else ensuring they are able to hear and see each other. These are basic requirements of video conferencing. Clear with this? And notice is very, very important. But I have not given a question from this, so just one topic you listen. What is it? Notice of meeting. You have to send it to every director. Even they send a notice to the company that we will not attend the meeting, even then you have to send them notice. Clear with this? If you don't send notice, you will be penalized with 25,000. Next, what is the time limit for notice? 7 days. Time limit is 7 days. Now, in writing to the registered address by hand delivery, post or electronic means. So can you hold the meeting for shorter period? Yes. Can I give notice of just 2 days and I hold the meeting? Yes. But one requirement is you have to make sure at least one independent director attends such shorter notice meeting. If one independent director is not present, then meeting will be held, but decisions will not be taken in meeting. Decisions will be circulated to all the directors. During circulation, at least one independent directors must give back their approval for the meeting. That is ratification. If independent director is not there in the company, this is not applicable. They can hold meeting in a shorter notice without satisfying these conditions. Are we clear? Ma'am, again, if director absent, power off during. Okay, you want me to explain the last attempt question? I will explain, my dear. Yes. December 2025, they have asked a question on board meetings. I'll explain. Kartikeya, crazy Kartikeya. Okay. So, let me explain this to you. The board meeting of Victoria Vibes Limited, an unlisted public company, having its registered office at Chennai. Where is the registered office? Chennai. Was convened at 8 p.m. on Sunday 5th January 2025 at Taj Palace, Mumbai. Luxury. Clear? They don't want some other hotel. Taj Palace. Total strength of the board was 14 directors. How many directors are there? Total strength is 14, out of which 2 positions are vacant. While calculating the quorum from total strength, you have to subtract the vacant positions. So now, for the purpose of quorum, what you will count? 12 by 3 or 2, whichever is higher. So what will be the quorum? Quorum will be 4. Now, first question. Examine the validity of venue, date and time. What's the venue? Taj Palace. Registered office is in Kolkata. Can they hold the meeting in Mumbai? Yes. Anywhere in India or outside India, they can hold board meeting. Clear? So, venue is valid. Date. Can they hold on 5th January? Absolutely yes. What is wrong with 5th January? Nothing is wrong. Clear? Next. Time 8 p.m. Even midnight also they can hold. It's their option. Clear with this? Everyone agrees. But one more concept here is Sunday is not a national holiday. We'll write down Sunday is a national holiday. No, you should not hold the meeting on Sunday. No, you can hold the meeting on Sunday. National holidays are only 3. 26th January, 15th August, October 2nd. In these 3 days, you can't hold the board meetings. That's all. Next, how should the notice of meeting be circulated to a director who is currently in London? What you will do if he's in London? Send him a post, expensive. Send him an email. That's all. Clear? Next, during the meeting, 7 directors attended, 3 in person, 2 from Bhopal, 2 from London. How many attended in person? 3 at Mumbai. Wonderful. Now, first we have to check the quorum. Ma'am, for quorum, will you count the people attending in video conferencing? Absolutely yes. So, how many directors are there? 7. What's the quorum? 4. So, basic quorum is fulfilled. Wonderful. Clear? Now, however, 5 minutes after commencement, the internet connection of 3 directors attending through video conferencing got disrupted and they could not participate further. So, out of 7, 3 directors who are attending online, they lost their connection. So, will you count these 3 persons for the purpose of quorum? No. 7 minus 3, how many are remaining? 4. What is the valid quorum? 4. So, can you continue the meeting with 4 directors? Answer is yes. Is it clear? Yes. So, chairman proceeded with the agenda and declared that all the resolutions were duly passed since the agenda papers and the draft resolutions have been circulated in advance. So, in addition, referring to the relevant provisions of the Companies Act and Companies Meeting Rules, decide the validity of the place of meeting and the resolutions passed. Ma'am, can it be conducted in national holiday? It can't be conducted on national holiday. So if let's say you are trying to conduct the meeting on 26th January, it will be invalid. You have to hold it on 27th or 25th January. Clear with this? That's all. So first question, holding the meeting in Taj Palace on Sunday 5th January is valid, permissible since Sunday is not a national holiday. Next, therefore, notice to a director present in London can be validly sent in electronic means to his registered email or by post to his registered address abroad. Clear with this? Now, notice you will send it through registered address, hand delivery, post or electronic means. Now, quorum for the meeting of the board of directors shall be 1/3 of the total strength of 2. What is a quorum? 2. 12. Why? Because 12 minus 2 vacant positions you should not count, which will be equal to 4 directors. At the commencement, at the beginning, how many are there? 7. Is the valid there? Is the quorum there? Yes, validly constituted. Next, effect of directors losing video connectivity. A director participating through video conferencing shall be counted for the purpose of quorum. Even if he's, even if he is attending through video conferencing, he will be counted for the purpose of quorum unless he is disconnected. In which case, he shall be considered not participating in the meeting. So, from the time of disconnection, he will be considered as not participating and he will not be counted in the quorum. Thus, once the 3 directors from London lost their internet connection, ceased to participate, the effective number of participating directors fell from 7 to 4, which is equal to quorum. Therefore, the resolution is passed and it is valid as the number of directors present at the meeting meets the quorum. What is it? Board meeting can be conducted in national holiday? No. But only adjourned meeting can't be done on national. Adjourned meeting, why you can't hold a national holiday is because automatically it's adjourned. Meeting is automatically adjourned to the next day, to the next week, same day, same time, same place. If automatically that next week date is national holiday, it will not be considered. Original board meeting, who will decide? Directors will decide. So they will decide and they will decide. Of course, it's not a national holiday. Since it's automatically adjourned, you can't hold it on national holiday. Mike Ross. Are you the Mike Ross from Suits? The best faculty for law in India, planning to get ranked in December 2026 with your guidance. All the very best. Hopefully you will get rank. Enchanted, charming. Did you understand? Where were we? Yes. Is it clear, my dear? Everyone, please let me know. Shall we continue? Honestly, this revision is very helpful. Thank you so much. You're welcome, Deepthi. Let's continue with the next question in our important questions. I think the first question, since in the incident case, Mr. Madhav, a director of Shine Paper Limited, has been authorized to draw, endorse, and all these administrative activities, Mr. Madhav will not be treated as managing director of the company, as he is authorized to do administrative acts of routine nature. Ma'am, I read somewhere that board meeting can be held in national holiday, only adjourned meeting can't be held. So don't worry, my dear. Most probably it will not be held because it's a national holiday, it will not be held. Okay, maybe I may be wrong, but usually board meetings are not held on national holiday. So I may be wrong. I will check the secretarial standards. So they will not be asking you in the exam, but ICMA has very clearly mentioned that it's not a national holiday, it can validly be held. Okay, I'll continue. Yes, so tomorrow in the case study live video, if I find something else, I will let you know. Okay, so question, the next, what will be the next part of the question? Procedure. Clear? What's the procedure? A managing director shall be appointed and the terms and conditions of such appointment and the remuneration payable be approved by board of directors at a meeting. The terms and conditions and remuneration approved as above shall be subject to approval of shareholders by resolution at the next general meeting. So this is what we have seen, the procedure. Yes or no? First, board meeting. Next, general meeting. Third, in case the such appointment is at variance to the conditions specified under Schedule 5, you're not following Schedule 5 conditions, then it shall be approved by central government. And a return is prescribed form, which is form number MR1 along with the prescribed fee, shall also be filed with the registrar within 60 days of the date of such appointment. If 5 directors were disconnected, can the meeting be valid? 7 are present, 5 are disconnected. So how many are left out? Only 2 are left out. What's the valid quorum? 4. Quorum is not available. Meeting will be adjourned. Clear? Next, moving on to question 32. International Technologies Limited, a listed company being managed by a managing director, proposes to pay the following managerial remuneration. This is regarding managerial remuneration. So, managerial remuneration, if we quickly revise, overall limit is 11%. Okay. Now, if there is only one managing director, that one person will receive maximum 5%. There is more than one managing director, then the overall all that managing directors, whole-time directors, they can receive 10%. Moving on to other directors, if there is a managing director, yes, then they will receive 1%. There is no managing director, they will receive 3%. Are we clear with the limits of remuneration? Ma'am, if quorum 4, present 7, in middle 4 lost their connection, then remaining 3 no. Quorum is not available. Meeting will be adjourned. Yes, wonderful, Somik. Overall 11, If there is only one managing director, he will receive 5% maximum. If there is more than one managing director, overall they will receive 10% maximum. If there is a managing director, other directors will receive 1%. If there is no managing director, other directors will receive 3% maximum. Clear with this? These individual limits, if you want to increase, you can pass a special resolution. Overall limit, you have to pass a resolution in general meeting, maybe ordinary resolution. It will be clarified under schedule 5. That's all. Clear with this? International Technologies Limited, a listed company. So here we have to check the first commission at the rate of 5% of net profits to a managing director. So since there is only one managing director, he can receive maximum 5%. So how much they are proposing to pay? 5%. Is it valid? Yes. Now, the directors other than managing director are proposed to be paid. So if there is a managing director, other directors can receive maximum 1%. Yes or no? Based on this, we'll check. Yes. Board meeting held through video and audio means venue of the meeting. Venue they'll clearly mention in the notice. If they are not mentioning the venue, we will assume registered office as the venue. Okay. So, directors other than managing director are proposed to be paid monthly remuneration of 50,000. Monthly already they are receiving 50,000. Also, commission at the rate of 1% of net profits of the company, subject to the condition that overall remuneration payable to the ordinary directors, including monthly remuneration payable to each of them, shall not exceed 2%. How can this be fair? They can receive maximum 1%. 1% will include commission as well as monthly remuneration. Together they have to receive 1%. It's not like 50% I'll receive every month and then again I'll receive separately 1%. Overall 2%. Overall 2% is not there. Overall 2% when it is allowed if you pass a special resolution. Are we clear? It's not just MD, right? If there is more than, managing director, whole-time director and manager. Not just managing director. Clear with this? Next. So, the company also proposes to pay suitable additional remuneration to Mr. Bhatt, a director, for professional services rendered as software engineer whenever such services are utilized. So generally, these limits, whatever we have seen, these limits are exclusive of the remuneration payable to director for professional services. Other than professional services, they are included. Are we clear with this? They are included. But if director is rendering professional services, they are not included in the limit. Separate payment will be made. Clear with this? That too, first they should be of professional nature. Next, whose opinion that they have professional qualification to render that services. NRC's opinion matters. Nomination Remuneration Committee. If NRC is not available, board. Clear with this? That's all. Now, International Technologies Limited, a listed company being managed by managing director, proposes to pay the following managerial remuneration. First, provides that except with the approval of company in special resolution, the remuneration payable to any one managing director, whole-time director or manager shall not exceed 5% of the net profits of the company. If there is more than such director, more than one, so there is one managing director, two whole-time directors are there, three of them together can receive 10%. Clear with this? Now, in the present case, since the International Technologies Limited is being managed by managing director, the commission at the rate of 5% of net profit, the managing director to Mr. Kamal is allowed and no approval of company in general meeting is required. Other services shall not be considered as remuneration only if it is of professional nature. Clear with this? Now, section 197, this is for other directors. If there is a managing director, whole-time director, then shall not exceed 1%. In any other case that there is no managing director or whole-time director, maximum 3%. If you want to exceed this, then you have to pass a special resolution. Listen very carefully. In the present case, maximum remuneration allowed to director other than managing director or whole-time director is 1%. Clear? Because The company is managed by managing director. Hence, if the company wants to fix a director's remuneration not more than 2%, if they want to fix a maximum of 2%, what they have to do? They have to pass a special resolution. Next, other services, generally they will be inclusive, except shall not be included if they are of professional nature, that too in the opinion of nomination remuneration committee or board of directors. Clear with this? So, in the present case, additional remuneration payable to Mr. Butt, a director, for professional services rendered by him, will not be included in the maximum managerial remuneration. And such additional remuneration shall be allowed, but opinion of nomination remuneration committee needs to be obtained. That's all. Moving on to the last but one question of Unit 7. Mr. Doubtful was appointed as Managing Director of Carefree Limited. Yeah, you can follow the words in the capsule, my dear. Okay. So, Mr. Doubtful was appointed as Managing Director of Carefree Industries Limited for a period of 5 years. When does his term begin? 1st of April 2016. And he is appointed for 5 years. So, what will be his term? 31st March 2017, first year. 31st March 2018, second year. 31st March 2019, third year. 31st March 2020, fourth year. 31st March 2021, fifth year. First year, second year, third year, fourth year, fifth year. Now, he is appointed for a period of 5 years as on 1st April 2016 on a salary of 12 lakhs per annum. Now, with other perquisites leave aside. Now, the board of directors of the company came to know about certain questionable transactions. So, some questionable transactions is there in the company. Who is performing that questionable transactions? Mr. Doubtful. Clear. Entered into by Mr. Doubtful and therefore terminated his services as managing director. When? Let me use another color. 1st March 2019. Date of termination. Mr. Doubtful termed his removal as illegal and claimed compensation from the company. First question that I want to ask you guys. Can he receive compensation? Yes or no? Think of it and give me the answer in the chat box. Good evening, ma'am. Only these two PDFs enough for 80. Not enough. Listen to the marathon, both the marathons, and revise the at least around 90% of the syllabus using the concept book. Then you will get 80. Some are saying no compensation. Actually, no. Yes, my dear Amrita, you can, my dear. You can study with the capsule. Not a problem. But make sure the wordings are exactly. Yes, he can receive the compensation because these are allegations. Questionable. Did the court declare that he is guilty of fraud? Did the NCLT declare that he is guilty of fraud or misconduct or breach of trust? No declaration is given. Based on some allegations on this person, you have removed him. Then pay him compensation. These are not confirmed. Questionable transactions. That is why he is eligible to receive compensation. So, first question is completed. Second, what is the amount of compensation? Clear? What is the amount of compensation as per section 202? the remuneration for the remaining tenure or 3 years, whichever is higher. Clear with this? Sorry, whichever is shorter. What is it? Remuneration for 3 years or remaining tenure, whichever is shorter. Clear with this? Now first, what is the remaining tenure? 2 years. Yes or no? 31st March 2019 to 31st March 2020, 1 year. 31st March 2020 to 31st March 2021, it is 1 year. But he is removed 1 month before the closure of 2019. So that is why 1 month also. So 2 years plus 1 month. How many months total? 25 months is the remaining tenure. So remaining tenure of 25 months or 3 years, 36 months, whichever is lower. What will be lower? Of course, 25 months. So if every month he is receiving 12, every month he is receiving 1 lakh. Per year he is receiving 12 lakhs. So what will be the compensation? 25 into 1 lakh, which is equal to 25 lakhs will be the compensation. Yes, average remuneration received during the tenure into remaining tenure or 3 years, whichever is shorter. Exactly. What's the average remuneration? Per month average he is receiving 1 lakh. Yes or no? That is what you have to write down over here. So, but it is not proper on the part of the company to withhold the payment of compensation on the basis of mere allegations. The compensation payable by the company to Mr. Doubtful would be 25 lakhs calculated at the rate of 12 lakhs per annum for the unexpired term of 25 months. If the allegations are true, they will use the word guilty of fraud. If they use the word guilty of fraud or guilty of, breach of conduct or gross negligence, then you have to, then no compensation will be received. Last question, direct question of question 20, the unit 7. Which companies are required to appoint KMP? First, every listed company. Second, every public company, but one condition should be satisfied. Paid up share capital should be 10 crores or more. Next, okay, these two companies should appoint whole-time KMP. Who has to be appointed? First person, either managing director or CEO or manager. If these 3 persons are also not available, at least whole-time director. That is the first person. Second, CFO. Third, company secretary. Clear with this? So, who has to be appointed? Managing director or else CEO or else manager, or in their absence a whole-time director, and company secretary and chief financial officer. And the second class of company, every private company, condition, paid up share capital 10 crores or more, has to appoint only one. Who is that person? Company secretary, whole-time company secretary. That's all. We are done. Now, shall we take a break or can we continue with the next 4 units? Unit 8, Unit 9, 10, 11. Please let me know in the chat box. break. Okay. MR want to be filed within 60 days, my dear. Ma'am, conduct a poll. Oh, that option is there, right? Oh, how do we conduct a poll? I need to conduct a poll with this account. Ma'am, I have studied all the chapters in Companies Act except amalgamation, FEMA, banking, corporate governance. Is that okay? Okay, not a problem. But okay. Corporate governance, please revise, no? Oh my god. People are very serious about the exam. Neck and neck between yes 49%, no 51%. Till now, no is only winning. So if you don't want a break, select the option no. Ma'am, in SEBI, what is the minimum subscription limit, refund period, and limit for general corporate purposes? I'll explain. No problem. Minimum subscription 90 period, refund is 4 days, general corporate purposes 25%. Do one thing, ask your friends to bring dinner, eat and listen. So 52% towards no break, so we will continue. We'll continue with finish off the Companies Act today. Ma'am, tomorrow live for other chapters. What do you say? Another live. End poll. Another poll. Again poll. But what is my opinion is, if I ask you if Companies Act is done today, tonight you can revise Companies Act on your own, and tomorrow fresh you can start with the other acts. But other acts, as I already told you, I'm not going to discuss in clear. Other acts will be done in 15 minutes. Why? Because just questions I'll show. Ma'am, lock-in period of security by promoters, because various sources show different dates and telling us amendment. Yeah, amendment is there. Minimum lock-in period is 18 months. Excess lock-in period is 6 months. First, let the poll continue for the other units. We'll start with unit 8. SEBI will discuss when we start other units. So first we'll start with the unit 8. Okay. So following is the extract of balance sheet of XYZ Limited as on 31st March 2024. So first they have given authorized capital. Okay. They've given paid up capital of 40 crores. And P&L account balance 22 crores. We'll consider this as free reserves. And share premium account 10 crores. Machinery revaluation account 11 crores. Imagine this to be in crores. Okay, crores or lakhs? I think this is in lakhs. I'm sorry, this is in lakhs. Okay, next, secured loan taken from a nationalized bank. This is borrowing. Okay, this is borrowing. Now really thanks for the clarification in detail. Okay, thank you, my dear. Okay, how long will the video be? So I estimate the video will be maximum till 10 o'clock. ये important questions के पास हो जाएंगे ना? पास तो बिल्कुल भी हो जाएंगे आप, टेंशन लेने की ज़रूरत नहीं है. Okay, so now the yield of government security may be taken as, so 1 year yield is 6.5%, 2 years yield is 6.7%, and 3 years yield is 6.9%. Now the question, ABC Limited has approached the company for grant of secured loan for 40 lakhs. They are approaching you. They are approaching XYZ Limited to grant a loan of 40 crores. Is it borrowing or granting? Granting. Okay. Now, for a tenure of 40 months. What's the tenure of the loan? 40 months. Now, can this loan be granted by Board of Directors at an interest rate of 6.5%? Ma'am, but in the study material, they have given 10% of aggregate paid up share capital and free reserves. What 10%? Now, listen. Okay. So, what are they asking? They are asking regarding whether the company can extend loan to another body corporate of value 40 lakhs. So, which section you have to consider? Section 186. Clear with this because it is granting. If it is borrowing, it is section 180. Now, so it's granting. Yes or no? What's the amount? 40 lakhs. Before we consider 40 lakhs is valid or invalid, you have to check a limit. What is the limit? What is the granting limit? 60% of paid up share capital plus free reserves plus securities premium, or 100% of free reserves plus securities premium. Are we clear? Whichever is higher. Whichever is higher. Now tell me, what is 60% of first paid up share capital plus free reserves plus securities premium? 40 plus 22 plus 10, which is equal to 72 lakhs. Yes, or else free reserves plus securities premium will be 22 plus 10. 32 of 100% will be 32. Next, 60% of 72 lakhs will be, what is 60% of 72 lakhs? Very nice. 43.2. So tell me whichever is higher. 43.2 is higher. So your limit for granting is 43.2. Now how much you proposed to grant? 40 lakhs. Can you grant 40 lakhs? Absolutely yes. Now comes the interest part. Whenever a company grants a loan, to check the interest rate, what you have to check? You have to check the yield of government security. Yield means return. So if a government security like a treasury bill or a bond is there, for 1 year how much it is yielding? 6.5. If you extend loan for 1 year, how much you have to charge? Minimum 6.5. Here you are extending loan for how many months? 40 months, which is closest to what years? Closest to 3 years, because it is 36 months plus 4 months. Yes or no? It is closest to 3 years. So minimum how much interest rate you have to charge? 6.9%. So 40 lakhs limit is satisfied. But can you grant this loan for 6.5%? No, you have to grant for 6.9%. Next, will your answer be different if the loan is 45 lakhs? If the loan is 45 lakhs, it is exceeding 43.2 lakhs. So that means you have to pass a special resolution. Yes, government yield to the closest tenure. What is the closest tenure? 3 years. Clear with this? So we'll write down the provision. So no company shall directly or indirectly give a loan, guarantee security, make investment exceeding 60% of paid up share capital, free reserves plus securities premium, or 100% of free reserves plus securities premium, whichever is more. Clear with this? But if it is above that prescribed limit, it should be authorized by special resolution. So, a loan under this section shall be given at a rate which is not lower than, that is minimum how much? 1 year, 3 year, 5 year, 10 year government security closest to the tenure of loan. Now, if you calculate authorized capital, you will not consider. Paid up capital 40. P&L balance considering as free reserve 22. Share premium account 10. Machinery revaluation reserve you will not consider. Borrowing will you consider? You will not consider. Now, what is 60%? 43.2 or 100% 32, whichever is higher. So, eligible amount is 43.2. So, proposed loan is 40. So, board of directors can grant 40 lakhs, but closest tenure 3 years, the government yield is 6.9%. So, they can't grant for 6.5%, but they can grant at 6.9%. And if the loan amount is 45 lakhs, board can grant such loan by taking prior approval by means of special resolution. Are we clear? Board resolution is also required. Unanimous board resolution is required, and also approval from public financial institution. Approval from public financial institution when it is not required, if it is less than the limits. And the next one is there is no default. That's not required to be written. Why? Because it's not given in the suggested answer. Not required to be written. Yes. Right. Now, this is again a direct question of section 187. June 2024 they have asked. June 2025 they have asked. Pattern, they can ask for June 2026 also. May or may not. Nothing's sure. Okay. So, these are, if a company is making investment, company is investing the money, that particular property or asset should be registered on whose name? Company's name. Who should hold it? Company should hold it. So, all investments made by the company, maybe in a property or a security or an asset, shall be held in its own name. Clear with this? But except if company has a subsidiary company. Yes or no? Company has a subsidiary company. Company can't be the single member. If 100% shareholding of subsidiary company is there with the holding company can't be the single member. As per Companies Act, there should be minimum 2 or minimum 7, so that the other persons can act as nominee. Other person can act as nominee. Clear with this? You can transfer the shares in their name to act as nominee. That's all. Next. So, there are 4 exceptional cases for which someone else is holding the asset. First, your banker is holding the shares for the purpose of collection of dividend. Next, your banker is holding the shares for easy facilitation of transfer. Third, depository, NSDL and CDSL, they are holding the shares because they are in the electronic form and you are the beneficial owner. And you have taken a loan from a third party and you have pledged the securities, then the third party can hold the asset. So, these are the 4 exceptions. Clear with this? That's all. And now moving on to the next question. Messrs. Pearson Limited, a public limited company engaged in manufacturing of steel pipes, has the following financial figures as per its latest audited financial statements. So, paid up share capital is given, general reserve is given, securities premium is given, loan taken from SBI is given, and turnover 575. Okay, company proposes to invite public deposits. This is the key here. So here we have to discuss about deposits. Different tenures ranging from 3 months to 36 months. So can they accept deposits from 3 months to 36 months? Yes. But if it is less than 6 months, the amount maximum is 10% of paid up share capital plus free reserves plus securities premium. Clear? We'll see carefully. So first question, is the company eligible to invite public deposits? When a company will become eligible, first condition, company should be a public limited company. Is the company public limited company? Yes. Second, net worth should be 100 crores or more, or else turnover should be 500 crores or more. So here net worth is 100 plus 20 plus 5, 125, and turnover is 575. So both the conditions are satisfied. Any one condition also is required to be satisfied. It's fine. Clear? So this is also satisfied. And the third one, before it accepts public deposit, it has to pass a special resolution. If these three are satisfied, the company will become eligible company. Clear with this? No, my dear, it's 10% of paid up share capital plus free reserves and securities premium. You have to consider securities premium. Yes. Now, is the company eligible? Yes. What is the limit for acceptance of deposits from public? From public, you can accept 25% of paid up share capital plus free reserves plus securities premium. And can it accept deposits for less than 6 months? Yes, up to 10% of paid up share capital plus free reserves plus securities premium. And how much company can accept deposits from its members? 35%. Limit for acceptance, let's say it can accept for 6 months to 36 months. There is no limit. Less than 6 months but more than or equal to 3 months, 10%. More than 36 months, it is not allowed. And how much can it accept deposits from public and members together? Sorry, members is 10%. Public and members together 35%. Are we clear with this? That's all. So prior consent by special resolution, net worth, turnover, filed a resolution. Also, it has to inform the credit rating to the public. And here net worth condition is fulfilled, turnover condition is fulfilled, so it can invite deposits from the public, and no company shall accept or renew deposits for a period of less than 6 months or 36 months. More than 36 months, less than 6 months but not less than 3 months, it is 10% of aggregate paid up share capital, free reserves plus securities premium. And from members, how much you can accept? 10% of 125, which is 12.5 crores. From public, you can accept 25%. So 35% will be equal to 43.75. From public, it is 31.25. From members, it is 12.5. Are we clear? Yes or no? Yes. Clear with this? Now moving on to the last question of the important questions, a direct question. I'm not going to discuss in detail. So they are asking about rule 7 and rule 8 or under section 73 rules. That is rules related to acceptance of deposits. First is appointment of trustee for depositors. So trustee means a person who is protecting the interest of depositors. Lakhs of depositors will be there. Every person can't take care regarding what's happening in the company, what are the financials, whether they're paying interest, whether they're paying on time or not. So that is why they will appoint a trustee who will take care of the concerns of the depositors. So that is why the duties of trustees will be to make sure they follow the terms and condition. They are creating charge or security on the company's assets, and they are paying the interest on time. So all these details, all these duties, whose responsibility it is? Trustee. Who can be appointed as a trustee? Any person. Trusteeship companies will be there. Debenture trustee registered with the SEBI, they can be appointed. Clear with this? Now, one form that we are going to discuss over here will be DPT 1. Sorry, DPT 2. DPT 2 is nothing but as soon as the trustee is appointed, there will be a trust deed between trustee and the company. The deed has to be filed in DPT 2 at least 7 days before the circular is issued. At least 7 days before the circular is issued. Clear with this? And the next one, who cannot be appointed as a debenture trustee? Director, KMP officer or employee of company, holding, subsidiary, associate, and also the depositor can't be the trustee. And indebted to the company, subsidiary, holding, associate, and having a material pecuniary relationship, as well as he's giving a guarantee. Next, he's related to any person above. These are disqualifications of a trustee and duties of trustee. Are we clear with this? So just read once, you will understand. Yes, wonderful, Nikki. Hopefully you read the questions clearly and present it clearly. You will get good marks. Okay. So we are done with unit 8 also. Now we'll start with unit 9. Okay. So unit 9 will be inspection, inquiry and investigation. So first question, a group of shareholders of FMG Limited made a complaint to the concerned registrar of companies. So that the company of the business of the company is being carried on for unlawful. So they have made the complaint to whom? ROC. And what's the complaint regarding? Unlawful and fraudulent purposes the business is being conducted. Now comes the question, whether ROC has the power to order for an inquiry into the affairs of the company. This is section 206. Section 206. Only under section 206 ROC will come into the picture. Other sections from 210 ROC will not come into the picture. Clear with this? First question, can ROC order an inquiry? Absolutely yes. What will be the procedure for the inquiry? First, inform about the inquiry. Clear with this? Next, you have to ask for the additional information before the inquiry. You have to give reasonable opportunity of being heard, and then you can start the inquiry. Anta Bhavya Madam Daya. Okay. So, first question. Yes, ROC has the power to order an inquiry as he deem fits after providing a reasonable opportunity of being heard to the person into the affairs of the company. If he is satisfied on a representation made to him that the business is going on for fraudulent, unlawful purpose or not compliance of the provisions of the act. Now, so if yes, state the procedure. What is the procedure? Inform the company. First, information. Next, call on the company to furnish information. Clear with this? Third, you will carry out the inquiry, but before that you have to give a reasonable opportunity of being heard. Next, whether inquiry should be pursued by ROC in case complaint is withdrawn by the same group of shareholders subsequent to the order of inquiry. Absolutely yes. Are we clear? Because that request, as soon as ROC receives, it's under the control of ROC to decide whether to carry out inquiry or not based on the decision of facts. So even if they have withdrawn, the inquiry will be carried out. Inquiry can be carried on by ROC even in case the complaint is withdrawn by the same group of shareholders subsequent to the order of inquiry. And the last question, whether central government has the power to direct the ROC to carry out the inquiry? Yes. When? Even central government believe that circumstances of fraud or else fraudulent purpose, unlawful purpose, or non-compliance of the act, if circumstances so warrant, what do you mean by so warrant, exist, central government can order ROC to carry out the inquiry. Ma'am, can you please tell the quorum for non-interested directors? Already I've discussed in detail, my dear, during I was discussing the unit 6. Please go to that. Okay. Yes, we have a lot to discuss. Again I can't be discussing the same. So that's all regarding the first question. Now moving on to the next question. Group of creditors of XYZ Limited makes a complaint to the ROC Gujarat alleging that the management of the company is indulging in destruction and falsification of accounting records of the company. So management of the company is involved in what? Destruction. False. They are destroying the accounting records and then they are falsifying the accounting records. Who have complained to the ROC? Creditors. Now, the complainants request the registrar to take immediate steps to seize the records of the company so that the management may not be allowed to tamper, that is, alter the records. Now, the complaint was received at 11 a.m. on 6th June 2018 and the registrar has attempted to enter the premise of company but has been denied by the company due to not having the order from special court. Is the contention of the company being valid? Absolutely yes. The difference between section 209 and section 220 is that both are search and seizure of books. But this is the complaint received by ROC. This is after the investigation is ordered by central government. So in this case, same content will be there. One small differentiation is you don't need to take the approval of special court. Are we clear with this? You don't need to take the approval of special court. But here central government is not involved. So that is why here you need to take the approval of special court. Are we clear with this? That is the difference between 209 and 220. Start from the beginning or else you can wait for 5 minutes. I'll complete this and you can listen. You can start from unit 10. Okay, so that's what will be the provision. First, what is section 209 saying here? If the company is engaged in destruction, multilateral, that is torn apart, altered, falsified, secreted, what? Company records, KMP records, director records, auditor record, company secretary records, the registrar has reasonable grounds to believe that, then after obtaining the order of special court only, they can seize the books. Clear with this? So they can enter and search and they can seize the books. So here, according to the above provisions, registrar may enter, search and seize the books only after obtaining the order of special court. Special court approval is definitely required. Clear with this? So in the given scenario, the registrar has failed to obtain the permission from the special court. So he is not authorized to enter the premises of the company and seize the books of accounts of XYZ Limited. The contention of XYZ Limited is valid. So the last question of unit 9. Ma'am, if remaining directors over interested directors, it shall not be less than 2. Yes. Number of non-interested directors cannot be less than 2. If it is less than 2, the meeting cannot be held for the transaction. The transaction should be adjourned. Now, Mr. Atul is an employee of the company ABC Limited. Investigation is going on him under the provisions of the Companies Act 2013. The company wants to terminate the employee on the grounds of investigation is going against him. So, they are investigating the employee regarding some or the other fraud or fraudulent purpose or some or the other case. They are investigating the employee. Clear with this? Now, they have filed the application to the tribunal for the approval of termination. Now, before we continue with the question, let me help you with the concept first. Section 218. During investigation against the company ordered by central government, what happens is, so company will be in a fear, no, what employee may disclose, some of their secrets, some confidential information he may reveal, or that we have falsified, he may tell it to the investigating authority. That is why what they'll do is they'll easily remove that employee. As soon as the investigation is going on against him, they'll remove him. Why? Because their fraud should not be disclosed outside. Clear with this? That is why for this situation, companies have put a condition that during investigation, if you want to remove a employee, you have to get the approval of tribunal. You have to get the approval of tribunal. Clear with this? Now, first things first, you need the approval of tribunal. Now, you have to wait for 30 days. How many days? 30 days. Clear with this? Ma'am, from the date of application, within the next 30 days, I have not received any reply. Approval, rejection, nothing is received. Then what happens? Directly company can terminate. Company can terminate the employee. Clear with this? That is the case. Now, case number 2. Within 30 days, tribunal has actually given an order. Tribunal has actually given an order. Order can be terminate or not to terminate the employee. Are we clear? If order is given, then only person can appeal. Then only person can appeal to the NCLAT. Are we clear with this? Why? Because the basic concept of appeal is, if you're not satisfied with the order of NCLT, then you'll go to NCLAT. If you check the first case here there is no order of tribunal only. That is why in this case, employee cannot appeal. Are we clear with this? So, let me discuss this once again. So, first, during investigation, if you want to take action against the employee, you have to get the approval of NCLT. Clear with this? Now, case number 1. Within 30 days, reply is received from NCLT. So, clear? So, what can be the reply? Terminate or not to terminate. Clear with this? Now, if they ask to terminate, then employee can appeal. Employee can appeal because order is given by, just a minute. Okay, sorry. So, during investigation, action taken against the employee, get approval from NCLT. So, there can be two scenarios. 30 days, NCLT reply is received. Then, either it can be terminate or not to terminate. If it is terminate, who is suffering? Employee is suffering, yes or no? So, if employee is not satisfied with the order of tribunal, employee can go appeal to NCLAT. Clear? Now, it has specified not to terminate. Then who is suffering? Company is suffering. So, that is why company will go appeal. Clear with this? Yes. Now, case number 2. Within 30 days, reply is not received. Then what you will assume? Company can take action against the employee. Are we clear? Now comes, since employee is suffering, does employee have any remedy? Can he appeal? Answer is no. Why? Because there is no order of tribunal to appeal. No. So that's why in this case, employee cannot appeal. That's all. Now is it okay? Please check. Now is the screen okay? Based on this, we'll quickly solve this question. So, here Mr. Atul, an employee of the company ABC, investigation is going on under him. The company wants to terminate. Company has filed an application to the tribunal. Now comes the case. Company has not received any reply from tribunal within 30 days of filing an application. So company is considering it as deemed approval. Can company consider it as deemed approval if no reply is received? Yes. So is the contention of company being valid in law? Yes. What remedy is available to Mr. Atul? If no order is issued, is there a remedy available to Mr. Atul? No. What remedy is available to Mr. Atul? If a reply of tribunal has been received within 30 days, what remedy is available if reply is received? He can go file an appeal to the NCLAT within 30 days from the date of receipt of the notice of objection. Decision of appellate tribunal will be final and binding. So what will be the conclusion? Yes, the termination of Mr. Atul made by the company is totally valid and you can consider it as deemed approval. Second, in this scenario, Mr. Atul has no remedy. Third, in this case, Mr. Atul can refer an appeal to appellate tribunal after receiving the letter of objection raised by tribunal. Clear with this? Last question of unit 9. 2 more units are there. We can complete very soon. Okay. So what is this last question? Powers of inspector for investigating related companies. So what are the related companies? Related company will be regarding holding company, subsidiary company, being managed by the company's managing director. All these related companies. We'll see. This is also a direct question. Clear with this? It was not asked in the past new syllabus attempt. Once again, I'm giving warning for the students. Check the audit and auditors chapter. What happened? All of a sudden, the last 4 attempts, no question. Here the question is there. Here also all of a sudden from June 2023, no question is there. June 2026, they can ask a question. So before skipping this unit, think. Okay. So this is section 219. Clear with this? If central government has ordered investigation to be carried out in a company, can I also investigate related companies? Yes. Let's look into this. What related companies you can investigate? First, body corporate which is or has any time been the company's subsidiary, holding, subsidiary of holding company. Clear? Now, body corporate, just a minute. Body corporate which is managed by whom? Company's managing director or manager. Who is managing? The original company which has been ordered investigation. This company's managing director is only the managing director of the other company. The other company can also be investigated. Clear with this? Next, other body corporate whose board of directors, investigation company, other company's board of directors are acting as per the direction of the investigating company's board of directors. Clear with this? So the other company can also be investigated. Board of directors whose board of directors comprises nominees of the company or is accustomed to act in accordance with the directions of the company or its directors. And then any person also can be investigated. Previously, he was the managing director or a former employee or former manager. How this investigation can be considered? Only with the prior approval of central government. These other companies can be investigated only with the approval of central government. So, the inspector, subject to the prior approval of central government, investigate into the affairs of the other body corporate or the managing director or manager if he considers relevant to the investigation of the affairs of the company for which he is appointed. So, inspector is permitted to investigate the holding company. So, we are done with the unit 9 also. So, everyone clear till now? Yes or no? So, we have been in the class for the past 4 hours. Are you listening? Till unit 9, is everyone clear? Yes or no? Okay, let's move on to Unit 10, Compromises, Arrangements and Amalgamation. So, first question is regarding approval of compromise or arrangement. So, first, a meeting of members of ABC Limited was convened under the orders of court to consider a scheme of compromise or arrangement. Here, court means tribunal. Notice of meeting was sent in the prescribed manner to all 600 members. Thought to skip Unit 9, now you'll revise. Very good. Good decision. So, how many members are there total? Total 600 members. Clear with this? Now, how many shares they are holding? 25 lakhs shares. Now, out of which how many attended the meeting? 450 members holding 15 lakhs worth shares. Now, out of this, 210 members holding 11 lakh shares voted in favor and 180 voted against. How many voted in favor? 180. How many voted in favor? 210. How many voted against? 180. Now, before we get started with the case solving, for approval of compromise or arrangement, two conditions should be satisfied. First, majority of the members must agree. Second, this majority should hold at least 3/4 in value of shares. This majority should hold at least 3/4. Two conditions should be satisfied. What are the two conditions? Where a majority of the persons at a meeting held representing 3/4 in value, voting in person, proxy ballot, agree to any compromise if such compromise is sanctioned by tribunal. The compromise can be 3/4 condition shall be counted for the following: creditors, class of creditors, or members or class of members. Are we clear? So the majority is dual. Number should be satisfied, majority should be satisfied, as well as value should also be satisfied. Clear with this? Now we'll see. In the case 600 members are there. How many attended the meeting? 450 attended the meeting. Now, but how many voted in the meeting? How many voted in the meeting? Only 390 members voted in the meeting. So, out of 390, what is majority? 390 divided by 2, which is equal to 195. So, if 196 members agree, then majority is fulfilled. How many have agreed? 210 members have voted in favor. So, first condition is satisfied. First condition is satisfied. Now, this 210 members should hold 3/4 value of shares. First, 390 members are holding how much value? 14 lakhs total. Why? Because 11 lakhs plus 3 lakhs. 14 lakhs they are holding. Now, 14 lakhs into 3/4 will be 10 lakhs 50,000. So, this 210 members should hold at least 10 lakhs 50,000. But 210 members are holding how much? 11 lakhs shares. Therefore, both the conditions are satisfied. The scheme will be approved by requisite majority. Are we clear with this? Two conditions. First, majority. Majority based on the number of people voted, not the number of people who are present at the meeting. Clear with this? Number of people voted. So, 196 majority. But how many voted? 210. Clear with this? Now, this 210 should be holding at least 3/4 of the total value. Total value is 14 lakhs. Clear with this? What is 3/4? 10 lakh 50,000. How much is 210 people holding? 11 lakhs. So, both the conditions are satisfied. That's all. Now comes the amendment. Already I have discussed this in marathon. I'm not going to discuss this in detail for again. Clear with this? So, new marathon, second part. ABC Limited is wholly owned subsidiary company of XYZ Limited. The company wants to make an application for the merger of holding and subsidiary companies. The company secretary of XYZ Limited is of the opinion that the company cannot apply for the merger of section 232. Company shall have to apply for the merger of section 233 is the contention of the company secretary valid. What is section 233 and 232? 232 is normal merger procedure. 233 is fast track mode of merger. Fast. That's all. Clear with this? Now, 233, which companies can go for fast track mode of merger? 2 or more small companies, holding company with wholly owned subsidiary company, 2 or more startup companies, 1 or more startup company with a small company, and this comes the amendments, 1 or more unlisted company with 1 or more unlisted company. But condition here is unlisted company values in aggregate of loans, debentures and deposits, it should not exceed 200 crores and it has not made the default of loans, deposits and debentures more than 30 days. If these two conditions are satisfied and you have a certificate from the auditor that you meet these two conditions, both unlisted companies can merge. Clear with this? Next, here holding company with subsidiary company, unlisted or listed, but make sure transferor company is not listed, then follow 232. If transferor company is listed, follow 232. Next, holding companies there. Holding has subsidiary A, subsidiary B. Subsidiary A and subsidiary B as merging. Clear with this? Then they can go for fast track mode of merger. But make sure again transferor company should not be a listed company. And again, holding company, foreign company. Subsidiary company is a wholly owned subsidiary Indian company. These both are merging. Fast track mode is applicable. Clear? Once again, please revise it on your own. And one more clarification regarding this question is, if I am a small company merging with another small company, I have two options. I can follow the normal procedure of 232 or else I can follow fast track mode of 233. For sure, I have to go through fast track mode only. It's not prescribed. May go for fast track mode. If I want, I can follow the complicated procedure. That's all. So, provisions given for fast track merger is section 233 are an optional nature, not a compulsion to the company. So, if a company wants to make an application as per 232, it can make. Hence, the company secretary of XYZ Limited has erred in the law and his contention is not valid as per the law. Company have the option to choose between normal process of the merger and fast track mode of merger. Small company, startup company, company unlisted. Yes, Nikki, you're right. Just realize that you have skipped a lot of portion. Oh, wonderful. The last question of Unit 10, which is merger or amalgamation ordered by central government. Again, this concept is discussed in part 2 of the marathon. This is a direct question. You can refer to this. Simple. Central government, if it orders that company A and company B has to merge, it will publish in the official gazette what assets to be transferred, how much each shareholder is, how many shares each shareholder is receiving, what will be their compensation, and all this will be published where? Official gazette. If you are not satisfied with receiving 1 share per 1 share, or you are not satisfied for receiving 1 share per 2 shares, then you can go file an application to tribunal. This is what is a provision under section 237. And the last unit of Companies Act, which is unit 11, prevention of oppression and mismanagement. So, prevention of oppression and mismanagement, the first question is regarding Foss versus Havotle. Now, instead of explaining this terminology, you can, I will just explain it briefly. Clear with this? So, what is Foss versus Havotle is? This is a case law in Victoria Company. Clear with this? Victoria Park Company, Victory Park Company. I'm so sorry. Victory Park Company. In this company, 2 shareholders, Foss and Turtle, 2 shareholders, has filed an application in the court, has sued the company's directors in the court. Reason, misappropriation of assets. So, they are misutilizing the company's assets for their personal purpose. This is the allegation. They have filed a suit in the court of law. Now, the court has rejected the suit and has given 2 rules, has established 2 rules. 1, proper plaintiff principle. What's a proper plaintiff principle? Always, if you are filing a suit against directors, shareholders, KMP or the company. Who has to initiate the suit? Company. Company in its own name of authentication by the company, that company can file a suit against the directors, not shareholders. Individual shareholders always they can't come and file a suit. Clear with this? Who has to file the suit? Company has to file the suit. Next principle, majority principle. Majority principle, that is majority principle. If a resolution is approved by majority, it is passed. It is passed. So company runs based on democracy. Based on the democracy principle, if majority are agreeing for a resolution, it is passed. You can't do anything about it. But it has also established exceptions. In these exceptions, these two rules are not applicable. What are the two rules? Proper plaintiff principle and majority rule principle. So majority rule principle and proper plaintiff principle are not applicable. First, Ultra Vires Act. What do you mean by ultra vires? Companies does not have the power to do such act. It is outside the scope of memorandum of association or articles of association. Then individual shareholder can file even if ultra vires is approved by majority, but still it is invalid. Clear with this? Next will be fraud on minority. On minority, they are committing fraud. They are not giving the information minority wants. They are diverting all the profits to the majority shareholder, majority directors, and they are giving remuneration to the majority shareholders. Clear with this? Majority shareholders will only be the directors, yes or no? So likewise, they are diverting the income. Yes, and they are not giving notices regarding the meeting to minority shareholders. So all this is what fraud on minority or minority oppression. In these two cases, fraud on minority oppression also, you can ignore the proper plaintiff principle and also you can ignore the rule of majority principle. Are we clear with this? And also other acts are also there, which is wrongdoing by the management, and instead of passing a special resolution, you pass an ordinary resolution, or else personal action by shareholders. So all these are cases of ignorance of majority rule and proper plaintiff principle. If you need detailed explanation, you can watch the first part marathon, prevention of oppression and mismanagement. Clear with this? So that is what you will write down. First, about the Foss and Hobottle case law, members can sue for the declaration that the resolution is void or order to restrain the company from passing when majority rule will not be applicable. Ultra Vires Act, fraud on minority, wrongdoers in charge of management, and you need to pass special majority, but you have passed simple majority, and personal actions by shareholder. Clear with this? So personal actions, if they are doing in contravention of the act, then the shareholders can file a suit against the person. That's all. Clear with this? This is Foss versus Harbottle. And the next question will be regarding section 244. If a shareholder has filed an application to the tribunal for oppression and mismanagement. Clear with this? Now, how many shareholders can validly file an application? So, minimum 100 members, 1/10 of the total number of members, that limit will be there. Then only application will be accepted by the tribunal. Clear with this? That limit we are going to study. And one more concept under 244, they have given limit regarding 100 members or 1/10. If you are not able to get 100 members or 1/10 of the total number of members, but your concern is genuine, your complaint is genuine, there is oppression, there is mismanagement in the company, you file the application by the tribunal can waive the requirements. It's a genuine application. Even if you are not able to satisfy the conditions, we will accept it and we will take action against them. So tribunal may waive off the requirements only under 244. That's all. Is this last? Yes, this is last. Okay, so we'll see. The issued and paid up capital of MNC Limited is 5 crores consisting of 5 lakhs equity shares of each. Both issued capital and paid up capital is same. Now, the said company has 500 members. A petition was submitted before the tribunal signed by 80 members holding
10,000 equity shares of the company for the purpose of relief against oppression and mismanagement. First, we'll check if they satisfied the limit. What is the limit? 100 members or 1/10 of the total number of members, whichever is less. Or else any member who is holding at least 1/10 of the issued share capital. First, check 100 members, only 80 members are satisfied. What is 1/10 of 500, which is equal to 50? So 50 has to apply. How many has applied? 80. So 80 condition is satisfied. That means, is it a valid application? Yes. Clear with this? Now continue the question. Examining the provisions of the Companies Act, decide whether the said petition is maintainable. Yes, the said petition is maintainable. Why? Because 50 should file, 80 are filing. Next. Also, explain the impact on the maintainability of the above petition if subsequently 40 members who had signed the petition withdrew their consent. They are telling that at the time of filing, you have to satisfy 100, 1/10. Not later on. Not later on. Later on, even if you withdraw also, the petition is still valid and it will be continued. Clear with this? The condition regarding 100 or 80, when it should be satisfied? During application. That's all. So, this is regarding the concept. Now, so shareholding pattern, if we check, 5 crores equity share capital is there, held by 500 members. Number of members who are making the petition is 80. Now, amount of share capital held by the members making the petition is 10 lakhs. Clear with this? Now, if you check 100 members or 50 members, whichever is lower. So, 50 will be the lower, or else members holding 1/10. What is 1/10 of 5 crores? 50 lakhs. Clear with this? But no worries. Why? Because if one condition is satisfied, it's more than enough. Even if you don't check the limit of issued share capital, just write down. So, petition made by 80 members meets the eligibility criteria specified under 244. Clear with this? As it exceeds the minimum requirement of 50. Now, the highlight here is therefore the petition is maintainable. But consent to be given by the shareholder is reckoned at the beginning of the proceedings. When you will check? At the beginning. So, the withdrawal of consent by any shareholder during the course of proceedings shall not affect the maintainability of the petition. Later on, even if you withdraw, it will still be maintained. That's all. Are we clear with this? Ma'am, I'm yet to complete the whole lecture, but thanks a lot. Hope you get lots of money. Oh my god, lots of money. Money I can, of course, but my main motto is you have to get lots of exemptions in law. Thank you, ma'am, for this revision. Recall missed concept also. Thank you. Okay, last question. We will be done with the Companies Act 2013. What is this last question? Section 245. Now I will answer the question which was asked in my Telegram channel. What is the difference between 241 and 245? What is 241? If there is oppression or mismanagement, members or creditors. Clear with this? Sorry. We are only referring to members. Members can file a petition with NCLT. How many members? 100 members or 1/10, whichever is lower, or else 1/10 of the issued share capital. If company is not having a share capital, 1/5 of the total number of members. Clear with this? And NCLT, if it is a genuine concern, it can waive the requirements. You don't need to have these many numbers if you have a genuine concern. Clear with this? And are you specifically asking NCLT a specific remedy? You're not. You're just telling we have oppression and mismanagement, please resolve. That's all. But when you check 245, this is class action suit. Class action suit. Who can file? Members can file. Second, even depositors can file. Class of members, class of depositors will file. Clear? That to whom they will file? NCLT. Whatever the requirement is regarding the 2% issued share capital or 5% issued share capital, where is it? Yes, 2% of issued share capital, it's a listed company, 5% it's an unlisted company. So 5% of the total number of members, 100 members, whatever these limits are there, these have to be satisfied. NCLT cannot waive. NCLT cannot waive. The limits should be satisfied. And here 245, you are asking a specific remedy. What do you mean by specific remedy? Please make this resolution void, or please put restriction on this majority, or please make this resolution, please, whatever the resolution which is passed, make the resolution as void. Or else if resolution is passed and people are taking action against the resolution, make them take action as per resolution. So you are asking for a specific remedy from court. That is 245. You're not asking a specific remedy, you're just complaining about the situation. That is 245. 241. That is different. Are we clear with this? Now, we'll just quickly revise section 245. This is such number of members or depositors of any class, if they are of the opinion that management is in the conduct of the affairs being conducted in a manner prejudicial. For sure, what word you have to use? Prejudicial to the interest of company or its members or depositors, they can file an application before the tribunal. 2. Specifically, you are asking restraining the company from committing an act ultra vires the articles or memorandum of the company. Others are also there. You can refer to the concept book or the capsule. Clear with this? Now, since we did not read the question first. A group of members holding 380 lakhs issued share capital. Clear? In Zoho Limited, listed company. It's a listed company, so you have to consider 2% having a total issued share capital of 15,000 lakhs as per the latest financial statements. Allege that the company board of director is conducting an act which is ultra vires the articles or the memorandum of the company without altering the memorandum or articles of the company. They are performing ultra vires, so they want that to be restrained. So specific remedy they are asking. That's why it is 245. And they make application to the tribunal to restrain the company from doing such ultra vires act. So that's why they will file section 245. So with reference to the provision of the Companies Act, ascertain whether application will be admitted by the tribunal. So how many are filing? 15,000 lakhs. Out of 15,000 lakhs, 380 lakhs. Clear with this? So how many can violently file an application since company has share capital? At least 5% of the total number of members or 100 members, whichever is less. Or else in case of a listed company, it is not less than 2% of the issued share capital. Here number of members is not given for us. What is given? Issued share capital is given. Now calculate 2% of 15,000 lakhs. What will be 2% of 15,000 lakhs? They have not calculated like this. We have calculated other way around. 380 is equal to 2.53% of 15,000. So 380 is equal to 2.53. So did they satisfy 2% condition? Answer is yes. You can do the other way around also. Are we clear with this? So, in the above case, members hold 2.53 lakhs out of 15,000 lakhs of issued share capital, which is a listed company, to make an application before tribunal. Hence, as members meet the condition of 2%, therefore, class action suit can be admitted by NCLT. Are we clear with this? So, that is what is the Companies Act. We have revised all the questions. So we have been revising since the past 4.5 hours. So if you still have any doubts, you can just message me. In the Telegram group, you will message. Either I will clarify or else someone else will clarify. So it will be much more quicker, or else you can message me personally. So with this, we are done with the Companies Act 2013. It's already 9:37. So what shall we do, my dear? We still have around 44 questions are there more. So under 241, if concerns is genuine, they can waive off. But in case of 245, no waive option is available. Yes, thanks a lot, Daya. Thank you. That was awesome, ma'am. If it is helpful, it's more than enough for me. And please make sure you revise by yourself also. Once again, you sit and revise, read out the provisions. Reading out helps a lot for especially revising theory subjects. So that's one thing that I recommend. Even if you're tired, you want to give up at any point of time, just go for a walk. Don't watch reels or short videos. It's a complete distraction out of your mind, especially during this tenure, during this time period. So if you want to take a break, listen to my marathon. If my marathon is also stressful for you, just keep aside your phone, books, close the books, go for a walk, talk to your mom, go to the kitchen, get something to eat. That's all. But don't watch anything digitally, because already you are taking in a lot of information. Again, information through the social media is not very helpful for you. Okay. So ma'am, when will you come tomorrow? I will come tomorrow morning. When you want me to come? Morning 4 a.m. Definitely people will not wake up, and I will not be able to wake up at 4 a.m. and I can't make such commitment to you. Compensation of loss, before I have seen average of 3 something, I didn't remember. Can you explain? Okay. Compensation means, so in our example, compensation is very clear. What is compensation? 1 lakh per month. Yes or no? Per month 1 lakh. But the provision says that if you are not able to calculate correct compensation for remaining tenure or for 3 years, correctly you don't know, because the person is managing director, whole-time director. He might have received compensation on profit. He may not receive fixed remuneration. He may have received 15 lakhs in the first year, and then 20 lakhs in the second year, and then 25 lakhs in the third year. Then what happens? You don't know fixed remuneration per month. So that is why for remaining tenure or 3 years, first calculate average. First calculate average of the preceding 3 years remuneration. Ma'am, he is only there for 2 years. 2 years average you calculate. Clear with this? Average you will get 1 value per year. So 1 value into the remaining tenure, or 1 value into the 3 years, whichever is lower. That's all. Ma'am, tomorrow morning session we'll have, ma'am. Today we'll finalize Companies Act revision. Okay, sure. Madam, at last, can you please, how many marks we get with Super 50 and MCQ? Ma'am, I have not revised company formation and conversion dividend from your capsule. The question mentioned in this PDF is enough. Yes. Ma'am, is Competition Act amendment for compromise applicable for this term? Yes, it's applicable. Madam, please tell minimum how many marks we can score from Super 50. Okay. Wait. Let me clarify this. I'll not disappear. First things first. To tell you the exact marks, how many will come in from my book, I can't give you an exact number. But I'm telling you, based on this PDFs alone in my marathon, you can easily score 50. I'm not talking about how many you can attempt. You can easily score 50. At least 70 marks you can attempt, my dear. I'm telling you, I have covered a lot of concepts. These are almost around 100 questions. MCQs are there. Case study MCQs are there. Marathon is there. You might have watched the marathon. Yes or no? Don't worry. And at the last minute, going for other books, other videos, other PDFs will not help you. Fix with one book. Even my PDF also, if you are listening for the first time, you already have one revision completed in your old book, follow old book. My PDF may confuse you because you might have learned some other concept. So this is not the time to search for new PDFs. Clear with this? Stick to one PDF at least from now till tomorrow, day after tomorrow, 10 o'clock. Ma'am, where can I get this PDF? Description box below. You will have Telegram channel link, and what do you say? There in the Telegram pinned comment you have the PDF. Ma'am, case study MC. Tomorrow I will come live for. I will tell you the timings. I'll inform in my Telegram channel. I'll inform the timings and I will schedule the live. Tomorrow we'll quickly, just for half an hour, we'll just revise the question and answers of the other acts and we will discuss the case study MCQs. Rupa, you're welcome, my dear. Thank you. Positive vibes. 7.5% limit of contribution is not updated on MCA website. Wait. One of the case study which was given, it was against SEBI. Supreme Court was involved. Clear? Supreme Court was involved and it has specified that it's not insider trading. It was against SEBI. Clear with this? So there are many questions in the ICMAI final examination where Supreme Court order based questions are given. From Competition Act it is given. From SEBI it is given, from IBC it is given. So should we consider Supreme Court orders based on these three questions which are given in the final examination and in the suggested answer they have specified as per the Supreme Court? Yes. So why will we not consider the, Supreme Court decision? I have also seen the MCA portal. I know in the MCA portal it's not updated, but Supreme Court order has struck down. Okay. So that's one thing you have to keep it in mind. Okay, so till right now I will still specify that 7.5% limit is applicable. Why? Because it is there. I'm not telling something wrong. It is there. Okay. So will there be any MCQ session? Bullet MCQs, there will not be session. Only case study MCQs, there will be a session. Bullet MCQs you can revise using the old video because it's all the same MCQs. Nothing has changed. Nothing has changed in the MCQ bank of ICMA. Nothing has changed in the study material also. And one more disclaimer I'm giving you. I have considered all the past question papers in the last 16 attempts. Yes, I have considered all the MQPs which are available since the new syllabus attempts. And the third one, I have considered all the ICMAI study material as well as MCQ bank MCQs. And the next, some of the CA study material questions are also considered in my book. So, before you, okay, maybe I have to cover MQP also. No, I have covered. Okay, if you want to trust this only single PDF, you can trust. Be it bullet MCQ PDF or case study PDF or the important question answer PDF. Ma'am, by any chance you have leaked paper? And not a chance. Not encouraging that also. Hope you have a great year and you will continue this support for us in future. Sure, for sure. Ma'am, if anyone have done selective paper study but covered the maximum weightage chapter, yeah, you can do it. Last minute strategy if I want to tell you, see, paper is for 128 marks. Yes, 128 marks. Let's imagine for sure 20 marks MCQ you will get based on the bullet MCQ or else the case study MCQs. For sure at least 20 you will get. Okay. So, other than this, keeping aside 30 marks of the MCQ, 98 marks are there. 98 marks. So, 98 marks choice. So, in this, at least we have to get 50. Assume we have to get 50. Not 50. Get 50. Okay. So, practically if you think about this, if you cover at least, not 60, at least 75% of the chapters completely. At least 75% of the chapters completely. 50 marks is a piece of cake. I'm telling you, out of 10, if you prepared 7 or 8, that is also more than enough. Clear with this? If you've skipped 2 to 3 chapters, that's not a concern right now. You don't need to open a new chapter now. At least out of 10, 7 has to be definitely prepared. 75% of the chapters, if you know, it's more than enough, my dear. Major change in the December MCQ, only one change, that IBC time extension is 270, not 180. Thank you so much. You boosted the confidence. You're welcome, Deepthi. Suda, like, I'm not able to pronounce this. 7701 Bhavya ma'am is best. Thank you. कौन सा चैप्टर करें? आपकी मर्जी. कौन सा चैप्टर करें? आपकी मर्जी. आप सेलेक्ट करो कौन सा चैप्टर इजी है पढ़ने के लिए, कौन सा चैप्टर हार्ड है, कौन सा चैप्टर से वेटेज है, कौन सा चैप्टर का क्वेश्चंस हम बहुत इजीली सॉल्व कर सकते हैं. बेस्ड ऑन दैट यू कैन डिसाइड. क्लियर विथ? अल्टीमेटली इट्स योर ऑप्शन. क्लियर विथ? आई एम नॉट अ पर्सन हु इज गोइंग टू गिव यू दैट इस चैप्टर्स पढ़ो, इसी चैप्टर में से क्वेश्चन आएगा. मैं भी नहीं बोल सकती हूँ, क्योंकि आई एम टेलिंग यू, क्वेश्चन पेपर एनालिसिस इज नॉट गिविंग अस scope of prediction. Clear? Somewhere it is given as 3:30. Overall time limit is 3:30. Overall time limit is 3:30. Tomorrow morning we'll discuss IBC, don't worry. Okay? Ma'am, Companies Act plus SEBI plus IBC plus corporate governance plus competition. Is this combo enough? I would recommend one more. Cyber security. Please read this also. Time. I will update in Telegram channel. So based on my schedule, I will update with. That's so sweet. Anmol. Deepak. Thank you. Rupa. Thank you. मैम को हिंदी आती है? Yes, not that perfectly, but your teaching is as beautiful as you. Thank you so much. Okay, my dear, so we are at the end of the session for today. It's already 9:50. So please have your dinner and don't watch reels, don't watch shorts. My sincere request. Immediately, once again, just go through the whole Companies Act, finish off the bullet MCQs video, and if you have doubts still in the Companies Act, rewatch the same video or else rewatch the marathon once again for that particular unit. Clear with this? Tomorrow morning we will check about other acts and case study MCQs. Okay, so thank you. Yeah, Devans from Kerala, thank you, my dear, and also someone else from Kerala. Irfan, Devans, thank you. Ma'am, if I blindly trust your PDF for descriptive, will I pass this attempt? Can you give assurance? Can I give assurance? What if all of a sudden the law paper is the toughest in the history of ICMAI? I can't give assurance. But you will pass. Pass of 40 is assured. From MCQ, I think based on the last 4 attempts of predictions I've made, minimum 26 marks have come from my PDF only. Zindabad from Hyderabad. Thank you, Nikki. Company law में डायरेक्टर KMP बोर्ड मीटिंग प्रिवेंशन सफिशिएंट है? सफिशिएंट नहीं है, माय डियर.
आपको तो अकाउंट्स ऑफ कंपनी करना पड़ेगा, एटलीस्ट अकाउंट्स ऑफ कंपनी, ऑडिट एंड ऑडिटर्स, ये दोनों तो करना पड़ेगा. इन्वेस्टमेंट एंड लोन्स बिल्कुल, फॉर श्योर. Balamurugan from Chennai, thank you. From Bangalore, Surya Gowda, thank you. Ma'am, is there any combination of acts in same question based on? No, not at all, not at all. There is no combination, possible combination at all. You can't find a possible combination, see. But maybe based on the MQP, we can say that Companies Act is being asked from the first 3 questions. 2, 3, 4, 5 Companies Act, and 6, 7, 8 is economic laws. We don't know. There is no possible case, no combination. Combination is not at all there. We can't say which question. And one last advice, try to at least write 90 marks. At least write 90 marks. Okay? At least write 90 marks. First 3 papers should be absolute wonder. They should believe that you are a ranker. First 3 papers. 4th paper, write whatever you want. Okay? So, and the next will be whatever is comfortable to you. Start with the MCQs, it will boost your confidence, and then you can start off with the easiest answer. You can write in any combination. So that's what I'm telling you. Presentation guidelines, you listen once. In my course it is there. Okay, so there I'll help you understand. If you want to skip, you can skip, my dear. सरफेसी एक्ट और इंश्योरेंस एक्ट में से किसके आने का ज़्यादा चांसेस है? सरफेसी. But insurance was not a surface most probably. Ma'am, is it MCQ video sufficient? Absolutely yes. Ma'am, fast track CIRP tomorrow I'll discuss. While I'm discussing IBC, I will discuss fast track CIRP. Ma'am, which are important in special contract? What special contract are we referring to? Ma'am, if I score 90 plus in law, what would be your gift? I don't know. Maybe I'll decide after you get marks. But of course, you'll get a good gift from my set. Not applicable for December attempt. 245 limit change. Ma'am, only business ethics I studied. What to do? Business ethics? You're asking me advice on CMA Inter? I can't. Yes, banking, insurance, FEMA, you can skip. What should be enough? My case study MCQ and bullet MCQ, that will be enough. And marathon also you have to watch. Ma'am, is it same as fast track matcha? Almost same as fast track matcha. Chapters को रिवाइज करो पहले, फिर MCQ मैराथन बाद में देख लेते हैं. पहले चैप्टर्स को रिवाइज करो. MCQs एग्जाम के दिन भी रिवाइज कर सकते हैं आप. FEMA, insurance, banking, SEBI, wholly exclude. No. SEBI you have to. If Companies Act is strong, which chapter you can skip? You can skip insurance, banking, FEMA. You can skip. Please help me after business ethics what to study. My dear, I can't give advice on CMA Inter. I have zero analysis on CMA Inter. I'm really sorry. Ma'am, is it okay to have some weak points in the chapter? Absolutely yes. No one's perfect. It's based on how confidently you are able to write down the questions that you know. So most probably out of the, 7 into 14 questions, maybe you only know 4. Superb, you can get 50. Maybe only 4. But other perfectly you know 4, others you can write on your own, remember some of the other provisions. It's well and good, no problem. Too much of anxiety and tension. If I pass group 3 this time, I'll become CMA. I can see you will become CMA day once, no problem. You will definitely, you have to come to BCCA to attend the fest after you pass. Okay. Takeover in SEBI, can we skip one question? You read obligations of transfer or company and target company and acquirer. What you will do नंदिनी? स्किप करो, क्या करेंगे अभी तो बिल्कुल भी समझ में नहीं आएगा क्योंकि वो बहुत ही कॉम्प्लिकेटेड चैप्टर्स हैं. एटलीस्ट कॉम्प्रोमाइज़ करो, टाइम है तो, नहीं तो डोंट वेस्ट द टाइम ऑन न्यू चैप्टर्स नाउ. इकोनॉमिक लॉज लिमिटेड चैप्टर्स बताने के लिए आप इकोनॉमिक लॉज में सेबी करो, साइबर सिक्योरिटी करो और competition, SEBI, competition, cyber security. At least revise these three in the last minute. Will the video be uploaded? This video will be there in the live section. You can view. For now, you revise this question and answer, it will be enough. Ma'am, can you please tell me that you are sure about this question will come? Confirm in June 2020, which may either in company sector or economic loss. For sure, मैं नहीं बता सकती क्योंकि it's really it's like if I have to give probability 70% chances, that's all, because we don't know. And don't go for probability now. You don't have any other option. You read with confidence only. You read. हाँ, सरफेसी एक्ट के लिए मेरा PDF बहुत सफिशेंट है और सिर्फ इंपॉर्टेंट क्वेश्चंस पढ़ के जाओ. अभी पहले पढ़ रहे हो तो इंपॉर्टेंट क्वेश्चंस पढ़ के जाओ. मैम, डू यू स्पीक तमिल? ना, इले. Unit and module. This is module and this is units in Companies Act. U is for unit in Companies Act, M is for module. Ma'am, is answer provided in your, okay, sufficient. Ma'am, please provide timestamp. Okay, sure, someone will definitely provide timestamp. Past year question के बेस पर हम टाइप ऑफ क्वेश्चंस एंड लेवल ऑफ क्वेश्चंस एक्सपेक्ट कर सकते हैं. इस बेसिस में ही मैं PDF बनाई हूँ और आप फिर से एनालिसिस मत करो, फिर से एक स्टडी मटेरियल मत निकालो. नो, नॉट एट ऑल. उसको ओपन मत करो क्योंकि न्यू डाउट्स everything, so don't open the study material now, not at all. Okay, so thank you my dear students, and stay tuned in the Telegram channel. I will be sharing the what do you say, and it will be scheduled in the YouTube also. If you don't want to see the Telegram chats scrolling time waste, it will be scheduled in the YouTube also. I will be scheduling the correct time, that time the class will start. Okay, most probably tomorrow morning. Thank you ma'am, watching from Jaipur. Thank you. How many languages do I know? I can speak in English, I can speak in Hindi, I can speak in Telugu. Telugu is my mother tongue. I am from Hyderabad. Ma'am, A category, B category, nothing is there. Ma'am, haven't done dividend. No. Marathons you have to watch for investments and loans, operation and books of accounts. Dividend, watch this video. At least two questions are there. At least two questions you do for dividend. Okay, investment and loans for sure you have to watch. Accounts you have to watch. Operation is, if it is complicated, don't. Ma'am, which chapter do I first? 10 out of 9, 10, 11. Do 10 first, then 11. Confidence matters a lot rather than knowledge. Mosam, watching from Haryana. Thank you. If you are talking about modules of 9, 10, 11, 10 cyber security you have to do, PMLA and then MSME. If you are talking about units of companies, first 2 compromises, then prevention of operation and then investment and loans. Sorry, inspection and inquiry. Sufficient for the exam, Nexo Royal. Yeah, for now you don't have any other option. At least do these and go. Watching from Delhi, thank you. So that's all for today. I am ending the live. So if you still have any queries, I already told you, Telegram mein message karo, doubts hai to people will clarify, or else you can message me personally on Telegram or WhatsApp if you have the number. And tomorrow morning I will update you. Most probably it will be before 10 or after 10 for sure, but not 7 a.m. 6 a.m. and all, because practically students will not attend. मैम कॉन्फिडेंस ही नहीं है, क्या करें. कल का लाइव अटेंड करो. कॉन्फिडेंट. ओके, आई एम सॉरी, दिस इज अ मैकबुक एंड ऑल दीज props will come. So tomorrow other chapters and case study MCQs. Okay, bye bye. Yes, it's relevant for this attempt also. Gautami, दिसंबर का वीडियो अभी भी रेलेवेंट है. मैम PDF टेलीग्राम ग्रुप में है. टेलीग्राम ग्रुप का टेलीग्राम ग्रुप का लिंक डिस्क्रिप्शन बॉक्स में है. बैंकिंग कंपनीज इंपॉर्टेंट क्वेश्चंस पढ़ो. IOCL ट्रेनिंग के बारे में मेरे को थोड़ा क्लैरिटी नहीं है माय डियर. सो send me a proper message, then I will ask. Can you suggest any one question that you're damn sure that will definitely come in this attempt? Any one question, please. One question, damn sure. CSR. After 12 a.m. will be fine, huh? Okay, sure, no problem. CSR may come damn sure. Mr. Jazz, I already told you. I think CSR. It may not be possible also, but CSR I think. Live will be available even after I end the live. Okay? So, stay tuned. On the YouTube, notifications on karo. Live schedule करने के बाद you will get the notification, or else in the Telegram channel you can see and you can attend my live. Thank you so much. Good night. Please continue the preparation, and no matter what, don't give up. Whatever the few chapters that you are going to study, no problem. Even if I said you study another new chapter, you are not able to, don't worry. Stick to the chapters you already know, because your confidence matters a lot rather than lot of knowledge. Clear with this? So whatever you know, make sure you write it perfectly. Presentation guidelines video you have to follow. Okay? So no SFIO आएगा question आ सकता है. Some more questions maybe from ma'am, my age is 32 only, stuck in final. I have completed industrial training from IOCL. If I cleared, రోహిత్ గారు నాకు తెలియదండి, కరెక్ట్గా నేను చెప్పలేను. సో ఒకసారి టెలిగ్రామ్లో నాకు మెసేజ్ చేయండి, లేదా వాట్సాప్లోనే మెసేజ్ చేయండి, లేదా ఈ వీడియో ఎండ్ అయిన తర్వాత సపరేట్ కామెంట్ పెట్టండి, నేను కనుక్కొని చెప్తాను. Some more I can't say for sure, my dear. Okay, for now that's all. I'm going to end the live. Just attend in the morning session. Bye. Okay, good night. MQP में से आएगा. MQP का questions है मेरे PDF में. Okay, MQP also you can prepare. Thank you. Don't worry, if you have any more queries you can ask in the morning session. Tomorrow live also I'll come. Please ma'am, in English. Okay, Rohit, what happens is, I understood your concern, but I can't tell you for sure what you have to do. So it's better you can message me in WhatsApp if you don't have my number. Message in the Telegram personally, or else after the video is ended, go to the comment section, not the live section. Go to the comment section and tell me your query. I will give you the reply. Just tomorrow I'll say, my dear. just before the life is not same as this PDF. The small company limit in this PDF is 10 crores mentioned, and extra question is also not there in the PDF. No. The new updated PDF is there, my dear. Please check now. See, go to the pinned comment. All the new pinned comments are the new PDFs only. Yes. Thank you so much, ma'am. You're the best. Thank you. I don't know your name. 306 something. Okay. Your words are very luck. Okay. Thank you. Good night, my dear. Bye bye. We'll see you tomorrow. Continue your preparation. Don't give up. Thank you. Yeah, my dear, you can depend on this. Okay. So if you want to ask anything else, please tomorrow other chapter MCQs in the same video. Sure. Thank you.